All right, good evening to everyone. If we can please have our bailiff call the court to order.
The Superior Court of the State of California, County of Santa Cruz, Department A is now in session. Judge Volkman presiding.
Thank you very much. Good evening to all of you. I'm Tim Volkman. I'm the presiding judge in the County of Santa Cruz. I've been a judge for 13 years. In every single year that I've been a judge in Santa Cruz County, I've been involved as a judge in this particular competition. I think this is a wonderful program, and I want to congratulate all the students, everyone involved with the teams for how successful you've been and for the fact that you're involved in this program this evening. I want to thank and congratulate the friends and family and parents of the individuals who are involved in this program and the supporters of the individuals who will be competing this evening. I want to thank the coaches for all of their efforts over the past several months in getting these students prepared for this competition. Every single year, it's my honor and privilege to serve as a judge in this competition. And every single year, it's one of the best and most beneficial things that I get an opportunity to do. So I am looking forward to working with all of you folks this evening. It's going to be my honor to work with everyone. I'll look forward to learning several things from every one of you this evening. And at this point, to help myself and the attorney scorers, will the prosecution team please state your name and role?
Good evening, Your Honor. My name is Chance Hostler, H-O-S-L-E-R, he, him pronouns, and I will be arguing the pretrial motion for the people of the state of California. May my co-counsel introduce themselves?
Absolutely.
Thank you.
Good evening, Your Honor. My name is Lolette Edwards, E-D-W-A-R-D-S, she, her pronouns, representing the people of the state of California in this action. Today, I will be conducting the direct examination of Officer Max Bird and the cross-examination of Aaron Sullivan. I will also be presenting the opening statement.
Good evening, Your Honor. My name is Meera Narayan, N-A-R-A-Y-A-N, representing the people of the state of California in this action. Today, I will be conducting the direct examinations of Drew Marshek and Dr. Kai Chavez, as well as the cross-examinations of Zuri O'Neal and Dr. Jess Bayart.
Good evening, Your Honor. My name is Nariana Bretholtz, B-R-E-T-H-O-L-T-Z, she, her pronouns, representing the people of the state of California in this action. Today, I'll be presenting the direct examination of Remy Mononttoya, as well as the cross-examination of Lee Crotty. I will also be presenting the closing argument. May our witnesses please introduce themselves?
Please.
Thank you.
Good evening, Your Honor. My name is Samuel Attard, A-T-T-A-R-D, he, him pronouns, and I'm Officer Max Bird.
Good evening, Your Honor. My name is Richard Katzen, K-A-T-Z-E-N, he, him pronouns, and I'll be Drew Marshek.
Good evening, Your Honor. My name is Mara Christian, C-H-R-I-S-T-I-A-N, she, her pronouns, and I'm Dr. Kai Chavez.
Good evening, Your Honor. My name is Elise Garza, G-A-R-Z-A. I'm Remy Mononttoya, she, her pronouns. At this time, may the clerk please present themselves to the court?
Yes.
Good evening, Your Honor. My name is Zora Freiwald, F-R-E-I-W-A-L-D, she, her pronouns. At this time, I would like to remind the court that I will be using a visual and verbal symbol for 2 minutes, 1 minute, 30 seconds, and stop. At this time, may our teacher and attorney coaches please introduce themselves?
Please.
Okay. Judge Volkman, Mary Fukai, attorney coach.
Good evening.
I think Gary's here. Maybe not.
All right. Anyone else who needs to introduce themselves on behalf of the prosecution team, please?
Katie Rocarries, school representative for Team Q.
There you go, with your main assistant. So that's perfect. Thank you.
We are in good shape.
Anyone else who needs to introduce themselves on behalf of the prosecution team? Thank you very much. The defense team, please state your names and roles at your convenience.
Good evening, Your Honor. Scoring attorneys. My name is Maya Manildi. That's Manildi. And tonight I'll be presenting the pretrial motion on behalf of the defense. May our trial attorneys now introduce themselves?
Please.
Good evening, Your Honor. Scoring attorneys. My name is Molly Ender Tatum. That's ENDERT-TATUM. Today, I'll be presenting the opening statements on behalf of the defense, as well as conducting the direct examination of Zuri O'Neal and the cross-examinations of Officer Max Bird and Drew Marshek.
Good evening, Your Honor. Scoring attorneys. My name's Ayana Bush. That's B-U-S-H, and tonight I will be conducting the direct examination of Aaron Sullivan and Dr. Jess Bayart, as well as the cross-examination of Dr. Chavez on the behalf of the defense.
Good evening, Your Honor. Scoring attorneys. My name is Ishel Aguilar Moore. That's AGUILAR-MOORE. And tonight I will be conducting the direct examination of my client, Lee Crotty, the cross-examination of Remy Mononttoya, and presenting the closing arguments on behalf of the defense. May our witnesses now introduce themselves?
Yes.
Good evening, Your Honor. Scoring attorneys. My name is Zora Martin Etemadi. That's MARTIN space ETEMADI, and tonight I'm Aaron Sullivan.
Good evening, Your Honor. Scoring attorneys. My name is Ella Henderson. That's HENDERSON, and tonight I am Zuri O'Neal.
Good evening, Your Honor. Scoring attorneys. My name is Karina Bunch. That's BUNCH, and tonight I am Dr. Jess Bayart.
Good evening, Your Honor. Scoring attorneys. My name is Rory Scheinbaum. That's SHEINBAUM, and tonight I am Lee Crotty. All of our team members go by she, her pronouns. May our bailiff now introduce himself?
Yes.
Good evening, Your Honor. Scoring attorneys. My name is Abby Anderson. That's ANDERSON, and tonight I'll be your bailiff. At this time, I'd like to remind everyone to please turn off all cell phones. May our attorney and teacher coaches introduce themselves?
Please.
Good evening, Your Honor. Scoring attorneys. My name is Guy French, and I'm a teacher coach for Team R.
Thank you very much. Anyone further on behalf of the defense team?
Yes, Your Honor. Michelle Welsh, attorney coach for Team R.
And Catherine Stoner, attorney coach for Team R.
Thank you very much for being here. I appreciate it. Anyone else on behalf of the defense team, please? Hearing none. I will advise all of you that we have 5 scoring attorneys this evening. They are excellent individuals, excellent attorneys, highly experienced, and I truly appreciate the donation of their time to serve as scoring attorneys for this competition. You must complete your presentations within the specified time limits. The clerk will signal you as your time for each section of the presentation begins to run out. When your total time for each section runs out, you will be stopped, even if you have not finished. Attorneys must call 4 witnesses within the time limit. This is a bench trial. At the end of the trial, I will render a verdict of guilty or not guilty in relationship to the charges brought. The teams will be rated based on the quality of their presentations, independent of my verdict. Barring unforeseen circumstances, no recesses will be called. If for any reason a recess is necessary, team members should remain in their appropriate places and should have no contact with spectators or coaches. Remember that objections are limited to the California Mock Trial Simplified Rules of Evidence located in the case packet. If there are no questions, our pretrial motion will begin. Both sides will have 4 minutes to present their arguments. The defense will begin. I will interrupt to ask clarifying questions. Time spent answering my questions is not included in the 4-minute time limit. At the conclusion of your arguments, each side will be offered 2 minutes of rebuttal time. Remember that the rebuttal time is to be used to counter your opponent's arguments. It cannot be used to raise new issues. Is counsel for the defense ready to begin?
Yes, Your Honor.
At your convenience, please.
For the convenience of the court, my name is Maya Manildi. Your Honor, the defense moves to strike to exclude the conversation that occurred in Officer Max Bird's car between Lee Crotty and Max Bird because Crotty was in custody during an interrogation and was not advised of their Miranda rights. This then violated Crotty's Fifth Amendment rights. The test for a custodial interrogation has two parts. First, the circumstances of the interrogation must objectively amount to custody, meaning that a reasonable person under those circumstances would believe that they are not free to leave.
What's the significance from your perspective of the fact that this was a willing participant getting into an unmarked vehicle with a plainclothes officer?
It was I'm sorry, can you restate that?
The factors in this case are it's an unmarked vehicle, it's a plainclothes officer, and the defendant willingly got into the vehicle. From your perspective, do those factors possess any significance in evaluating whether I should exclude this evidence?
Well, Your Honor, Crotty knew that Officer Bird was the officer who arrested Remy Mononttoya for burglary and assault. That shows that Officer Bird, despite having casual clothes, was still a police officer. Furthermore, the radio in the car began playing, and Crotty saw this, so they realized that it was a official cop car, and therefore it would not amount to a casual situation.
Thank you very much. Please continue.
The second part of the test for custodial interrogation is that there must be an interrogation, which can be questioning by a law enforcement officer or statements made by the officer that the officer should know would produce incriminating responses. This situation was custodial under the two-part test. Crotty was in custody and not allowed to leave based on a reasonable person's perspective. A reasonable person would believe that they cannot say no to a police officer. Crotty got in the car without even changing out of their pajamas. They could have reasonably believed that they could not say no to Officer Bird, especially since Crotty knew, as I had previously stated, that Officer Bird was the officer who arrested Remy. And once Bird began talking to Crotty, they were in a moving car, a situation where Crotty was unable to freely leave.
Even if I accept your argument that this was a custodial situation, why is this dynamic not similar to the Lewis case where the setting might have been custodial, but they found that it was not an interrogation?
Your Honor, in Lewis, the defendant initiated the conversation between the officer and themselves, and the defendant and the officer had a previous relation, so the conversation was held casual. But in our case, Officer Bird and Crotty had no previous relationship, and Officer Bird was the officer who arrested Remy. So it is arguable that the situation is exactly opposite from ours.
Thank you very much. Please continue.
The car may not have been perceived as custodial. So the situation at first may not have been perceived as the car may not have been perceived as an official cop car. So the situation at first may not have been perceived as custodial. But Crotty soon noticed the officer's radio, an observation that Bird was aware of, but resumed the conversation, knowing that it would produce an incriminating statement. This was also an interrogation under the two-part test. Stansbury v. California holds that a police officer's subjective and undisclosed conclusions do not determine when a suspect is considered in custody. If those beliefs are conveyed to the defendant, leading them to believing that they are in custody, then a Miranda warning is necessary. A person in Crotty's circumstances would have reasonably believed that Officer Bird intended to get Crotty to confess that they were a part of Remy's assault. Crotty states on page 36, lines 3 to 6, quote, "Officer Bird tried explaining that that wasn't the intention, but I knew it was, and I didn't want Officer Bird to think that I was at fault for Remy's actions, which seemed to be the implication," unquote.
What did the officer say that you contend placed him in a position where he knew he was reasonably likely to elicit an incriminating response?
Officer Byrd accuses Crotty of being an anarchist, a term that is not casual, and then further provokes them by saying that you'd have to admit when your content is taken out of context that people would take it that way.
Thank you. Please continue.
Thank you. In both Officer Byrd and Crotty's testimonies, it mentions how nervous Crotty was acting at this point, which Byrd was aware of. In the conversation, as I previously stated, Officer Byrd purposely used language that would antagonize Crotty. Byrd didn't just talk about Crotty's YouTube channel, they called Crotty an anarchist. By getting them riled up and defensive about their character and career, Crotty was more likely to say something self-incriminating. In People v. Boyer, the defendant was in custody, asked for a lawyer, and was not given a Miranda warning. So the statements were held inadmissible. In our case, Crotty asked if they needed to call their lawyer, and Byrd said no. So the statements should be held inadmissible.
Why shouldn't the court consider this a volunteered statement like in People v. Torres?
In People v. Torres, the defendant was not prompted by an officer by any questioning, and the statements were spontaneous. But in our case, Crotty was prompted by Byrd's aggressive questioning that led to Crotty making those incriminating statements.
Thank you. Please continue.
All of this shows that Crotty's Fifth Amendment rights had been violated. Your Honor, the defense asks that you hold the statements made during the conversation between Officer Max Byrd and Lee Crotty to be inadmissible. Thank you.
Thank you, counsel. Prosecution wish to proceed?
Yes, Your Honor. May I begin?
At your convenience. Thank you.
Thank you. Your Honor, Lee Crotty's Fifth Amendment rights were not violated on February 16th, and the conversation between she and Officer Byrd on the same day should not be excluded. In order for a reading of Miranda rights to be necessary, the defendant would have to be in custody being interrogated. Because no interrogation occurred and Crotty was not in custody, a reading of Miranda rights was not necessary. A reasonable person in Crotty's position would not have believed that she was in custody based on the plainclothes officer and the lack of barrier.
Whoops, I think someone may not have muted. Let's make sure everybody's muted.
Oh, nice. She just left.
That's all. I know I missed. I wasn't able to get up. I just finished my meeting.
Counsel, please indulge me for a moment. Thank you. This will not count against counsel's time.
No.
Thank you, Your Honor. May I
All
continue?
right. Thank you very much. Please continue.
Thank you. A reasonable person in Crotty's position would not have believed that he was in custody based on the unmarked car and the plainclothes officer. Crotty had no reason to believe that she was not free to leave. She had gotten in the vehicle voluntarily and could have asked Officer Byrd to pull over and let her out at any time. The conversation between the defendant—
in a police car, isn't being in the back of a police car by definition a coercive environment?
Not necessarily, Your Honor. I believe that it might not necessarily have been a coercive environment, considering that Officer Byrd had just arrested Remy Mononttoya previously and put Remy Mononttoya in handcuffs, and Lee Crotty had seen that situation occur. And so the contrast would have been obvious to a reasonable person in Lee Crotty's position. Lee Crotty was not in handcuffs. Lee Crotty had gotten in the vehicle voluntarily to go down to the police station for an interview. It was not an arrest, so Lee Crotty was not in custody.
Thank you. Why do you feel, if indeed you feel this way, that this situation is different than People v. Boyer?
I believe that this situation is different from People v. Boyer because in the case of People v. Boyer, the defendant attempted to exert their Miranda rights multiple times and was denied. However, that is not the case for this conversation between Lee Crotty and Officer Byrd. Lee Crotty did ask for an attorney near the end of the car ride, and they arrived at the police station, and Lee Crotty was permitted to speak to an attorney later that day.
Thank you. Please continue.
Thank you, Your Honor. The conversation between the defendant and the officer was not designed to produce an incriminating response. In the case of Rhode Island v. Innis, after the defendant was arrested, the police officers discussed in front of the defendant how a gun used in the case might be found by a child. This caused the defendant to reveal the location of the gun to the officers. This conversation between officers was not considered to be interrogation because the officers would not have known that this would elicit an incriminating response like this from the defendant. Crotty and Bird's conversation started concerning topics such as the former's career via YouTube, having nothing to do with Remy or the crime itself. It was Crotty who volunteered facts that might be relevant to the case, and even after this, Bird reaffirmed that this was not an interrogation, but a casual conversation by saying, "Nobody was accusing you of anything, Lee." He even used the defendant's first name. This conversation was obviously not designed to elicit an incriminating response. The conversation ended after Crotty requested to speak to an attorney just as they pulled up to the police station and waited outside, free to leave. According to People v. Andresen, casual conversations are admissible without Miranda rights being read. Police officers asked the defendant casual questions about his life and interests, and it was not considered an interrogation. In this case, Officer Bird also asked Crotty about her life and interests, her job, and her thoughts about her work. Bird repeatedly made clear that this conversation was casual via his language and tone, even clarifying, "No, that's not what I meant," when Crotty assumed that he was trying to speak on the case.
Couldn't a
Your
reasonable
Honor, I have
person, and I'm sorry to interrupt you, counsel, couldn't a reasonable person conclude that the officer's comments were indeed intended to elicit an incriminating response? It was more than just a casual conversation. There was a certain level of challenge that was offered by the officer to Mr. Crotty. What's your view?
Well, Your Honor, we're not completely sure of Officer Bird's level of familiarity with Lee Crotty's YouTube channel. So there's no way to extrapolate reasonably what knowledge Officer Bird would have had in regards to how much Lee Crotty may have thought of herself as an anarchist. Lee Crotty's YouTube channel was openly anti-government, something that's often associated with anarchists. So using the word anarchist in association with Lee Crotty isn't something that a police officer would necessarily have known would elicit an incriminating response. So it seems unlikely that Officer Bird would have specifically designed this conversation in order to get information about the case.
Thank you. Please continue.
Thank you, Your Honor. Your Honor, I have to ask that you deny the defense's motion to exclude the conversation between Lee Crotty and Officer Bird on February 16th. Any new information gained from this conversation was not as a result of a custodial interrogation, but Crotty willingly volunteering information of her own accord. Thank you.
Thank you very much. Any response and/or rebuttal from the defense, please?
Yes, Your Honor.
At your convenience.
A reasonable person would believe that they are not free to leave, especially someone in Crotty's circumstances. Though these circumstances being that they were in a moving car. Crotty could have felt very uncomfortable having to ask Officer Bird explicitly to pull over and let them out of the vehicle, especially since they had gotten in with their pajamas fully on.
Again, let's presume, just for the sake of your argument, that I accept that this is a custodial situation. How is the back and forth, if even one can call it back and forth, between these two individuals considered an interrogation?
The conversation between Crotty and Bird would be considered an interrogation because of the aggressive language that Officer Bird used with Crotty. They called them an anarchist, a term that Crotty could take as offensive. Officer Bird should have known that Crotty would take this offensively because they did bring up their channel, showing that they would know and should know how passionate that Crotty was about their work. And by calling them an anarchist, it would offend them. Furthermore, Officer Bird continued to provoke them by saying that you'd have to admit when your content is taken out of context that people would take it that way.
Thank you very much. Please continue.
The prosecution cited Andresen. And the Andresen case is exactly opposite from ours because the officer was having a conversation with the defendant about their life and interests, intending to avoid any aggression due to the defendant's angry and delusional demeanor. But in our case, Officer Byrd called Crotty an anarchist, as I had previously stated. That and then went on to further provoke them. And said that you'd have to admit when your content is taken out of context that people would take it that way, referring back to their accusation of being an anarchist.
Keeping in mind Andresen in relationship to whether or not this was a quote unquote casual conversation, and keeping in mind Torres regarding the issue of whether there was a volunteered statement, what significance, if any, should the court place upon the fact that Mr. Crotty was not even responding to a question when he offered his information?
The conclusion that the court should draw is that in these cases, the conversations were held casual. But in our case, there was no casual conversation.
Thank you very much. Please continue.
That is all. Thank you, Your Honor.
Thank you. Anything further on behalf of the prosecution, please? And I'm waiting to hear if there's anything left from the prosecution. Just so I'm not hovering in space here, if anyone can get on the line and make certain that they're hearing me at this point, I would appreciate it.
Your Honor, you're coming through loud and clear. And
Fantastic. Thank you very much. I just want to make sure that it wasn't just me.
It looks like the prosecution's back up. She's muted, but he's muted, but he's back up. If he unmutes, he can finish.
All right. If counsel for the prosecution could please unmute and we can begin with your rebuttal argument, I would appreciate it.
Oh, I'm sorry, Your Honor. I completely spaced out for a moment.
That's all right. This is an unusual format, but I appreciate everyone's flexibility. At your convenience, counsel.
Thank you. Your Honor, I'd like to talk about the defense saying that Lee Crotty did not initiate the conversation between Lee Crotty and Officer Byrd. While this is technically true, and Lee Crotty did not initiate the conversation completely, Lee Crotty initiated the part of the conversation concerning Remy Mononttoya and the case and the events that had just transpired completely on her own. The last thing that Officer Byrd said before Lee Crotty went on a rant about Remy Mononttoya was, "You have to admit that your comments, that your channel can be taken that way without context," or something to that effect. This was in reference to anarchy, which is not necessarily especially related to the case at hand. It was at this point that Lee Crotty brought up Remy Mononttoya and events that had previously occurred completely voluntarily. I'd also like to bring up Stansbury versus California. The defense brings up Stansbury versus California to say correctly that the opinion of an officer only matters to the extent that it is communicated to the defendant. Let's look at what was communicated to the defendant, Lee Crotty. Officer Byrd said, "No, nobody was accusing you of anything, Lee. No, that's not what I meant." Statements that clearly get across that Officer Byrd was not trying to interrogate Lee Crotty. This was communicated to Lee Crotty clearly. A reasonable person in Lee Crotty's position would not have believed that she was being interrogated.
Shouldn't the court be cautious about accepting the last point of your argument 100% when we have a situation where an individual is sitting in the back of a moving police car? And what I mean by that is, shouldn't the court be cautious about placing too much significance on whether the statement was volunteered or whether it was in a casual conversation when the circumstances surrounding this contact are so coercive? Your views, please.
Well, Your Honor, I don't believe that the police car with Lee Crotty and Officer Byrd could be considered a coercive environment. Officer Byrd did not threaten Lee Crotty with violence. Officer Byrd did not yell at Lee Crotty. Officer Byrd simply initiated a conversation about something completely unrelated to the case without using words that pressured Lee Crotty or that Officer Byrd would know might pressure Lee Crotty. And so Lee Crotty was not a reasonable person in Lee Crotty's position would not have believed that they were in a coercive environment. So what Lee Crotty volunteered was completely of her own accord and not as the result of coercion.
Thank you very much. Please continue.
Your Honor, I have to ask that you deny the defense's motion to exclude the conversation between Lee Crotty and Officer Byrd on February 16th on the grounds that Lee Crotty's Fifth Amendment rights were not violated. Thank you, Your Honor.
Thank you very much. I appreciate the input of both counsel. Before I rule on this motion, students may confer with their attorney or teacher coaches regarding any trial irregularities. Please do so now, and I'll give you a few seconds for that.
Nothing from the prosecution, Your Honor.
Thank you. Any concerns from the defense?
None, Your Honor.
All right, thank you very much. So the matter is submitted at this point. Again, I appreciate the arguments of both sides. I've had an opportunity before we all met today to review all of the facts concerning this matter, all of the case law, all of the statutes. I'm going to respectfully deny the motion to exclude. We will proceed with the trial at this point. The people of the state of California are charging the defendant Lee Crotty on 2 counts. Number 1, aiding and abetting a first-degree burglary committed by Remy Mononttoya. And number 2, as an accessory after the fact to a felony committed by Remy Mononttoya. From the prosecution's perspective, do you have any physical evidence that you'd like to present for inspection?
Yes, Your Honor. The prosecution moves that Exhibit A, which is a photograph of Drew Marshek's briefcase, Exhibit B, which is a faithful and accurate transcript of the February 12th Twitter group chat between Lee Crotty, Remy Mononttoya, Zuri O'Neal, Christopher DeMario, Buzz Darkman, Taylor Gold, and Michelle Wolf. And Exhibit C, which is a faithful and accurate transcript of a February 14th WhatsApp text conversation between Lee Crotty and Remy Mononttoya, all be pre-marked for identification.
Thank you. Any objections from the defense?
None, Your Honor.
Those will all be in evidence. At this point, we'll proceed with opening statements. Is the prosecution ready with its opening statement?
Yes, Your Honor.
All right.
And for the convenience of the court, my name is Lillette Edwards. May I begin?
Yes.
Your Honor, it's common for celebrities to foster some personal connection with fans. But the interactions between the defendant, Lee Crotty, a conspiracy YouTuber, and Remy Mononttoya, her most ardent fan, were anything but typical. The defendant knew what she was doing when she chose Ms. Mononttoya. Today, the prosecution will prove that the defendant knowingly persuaded Remy Mononttoya to break into the house of a government agent and take confidential documents, and then assisted Ms. Mononttoya in avoiding the police. On February 9th, Lee Crotty got the opportunity of a lifetime. She received confidential government documents from an anonymous source appearing to confirm the existence of UFOs. February 12th, the defendant sent a preview clip of a YouTube video she was filming featuring those documents to a private group chat, which included Remy Mononttoya. Clearly visible on the document in the clip are the name and home address of the victim, Drew Marshek. Ms. Mononttoya will testify that she had had numerous interactions with the defendant in the past, both in person and online. On February 14th, the day after the full video was posted, this time with the name and address of the victim redacted, the defendant contacted Ms. Mononttoya personally. She directed Ms. Mononttoya to get into Mr. Marshek's house and take the rest of the documents. Those documents absolutely had to be acquired. Ms. Mononttoya confirmed she had the address and agreed to do what the defendant directed. The next day, Mononttoya did just that. She broke into the house and stole Drew Marshek's briefcase and other documents, assaulting Mr. Marshek as she made her escape. Ms. Mononttoya immediately went to the meet and greet event that the defendant was holding, as planned. Ms. Mononttoya told Lee that she got the documents Lee wanted, but the plan had gone wrong. The defendant embraced her, had her wait until the end of the event, and then drove Ms. Mononttoya to the defendant's house. Ms. Mononttoya asked the defendant for a place to lie low in case she had been followed, and was given a guest room. The next morning, Ms. Mononttoya was identified and arrested on the front lawn. Officer Max Bird will recount the defendant's reaction to the arrest. He will detail for the court how the defendant, without prompting, confessed that she knew Ms. Mononttoya to be aggressive at times and had personally directed Ms. Mononttoya to go get the documents from the victim's home. Dr. Kai Chavez will explain how the defendant created a toxic environment among her fan base and used her creation to target Drew Marshek, and ultimately to direct Remy Mononttoya to burglarize Mr. Marshek's house. Your Honor, for a verdict of guilty on both charges, the evidence needs only to prove, 1, that Lee Crotty advised and encouraged Remy Mononttoya to commit a burglary, and 2, that she knowingly concealed her from the police. Lee Crotty is condemned by her own words. By the end of this trial, there will be no question of her guilt. Thank you.
Thank you very much. Does the defense wish to submit an opening statement at this time?
Yes, Your Honor. May I begin?
At your convenience. Thank you.
Good evening, Your Honor. My name is Molly Under Tatum, and it is my pleasure to be representing Lee Crotty in this important case. My client, Lee Crotty, is falsely accused of aiding and abetting first-degree burglary and accessory after the fact. Ms. Crotty is a former journalist and is now running an informative YouTube channel to spread an important message. One of her fans took this message too far, though, and Ms. Crotty should not be held accountable in any way for that. But let me explain. This case began on February 9th with an envelope that arrived at Ms. Crotty's door with contents that involved UFOs and extraterrestrials. Ms. Crotty was thrilled. She readily made a YouTube video about it, and on February 12th, posted a small sneak peek clip of it to a group chat of her loyal followers, as she often does. Then, Ms. Crotty texted Remy Mononttoya, a loyal fan, to tell them to go pick up some documents that belong to Drew Marshek. But that is when Remy took things too far. Ms. Crotty never expected Mononttoya to break into Marshek's house and steal. Mononttoya then fled to a cafe where Ms. Crotty was hosting a meet and greet for her fans. Ms. Crotty never understood what had happened or what Mononttoya had done. Mononttoya attempted to explain, but they were far too distraught and upset to get any kind of a point across, and Ms. Crotty was extremely worried about them. Mononttoya then asked Ms. Crotty if they could stay at their house for a while to lay low, and Ms. Crotty, wanting to help her avid admirer, and because she was so worried, obliged and let Remy stay the night. The next morning, Mononttoya was arrested, to Ms. Crotty's utter shock. A week later, Ms. Crotty was arrested too. Today, you'll hear from 4 witnesses on the side of the defense. First, you'll hear from Aaron Sullivan, Ms. Crotty's dedicated and hardworking agent. You'll hear that Ms. Crotty graciously engages with her fans, and that wanting to help her fans is typical behavior of Ms. Crotty. Next, the defense will call Zuri O'Neal to the stand. Ms. O'Neal will explain that these group chats were simply a stress-relieving place to vent, and that they were completely harmless. The third witness is a professor of sociology named Dr. Jess Bayart. Dr. Bayart will explain that Ms. Crotty isn't the leader of a movement. Ms. Crotty simply serves as an inspiration for others of the same mind who want to make a difference. Taking this into account, Dr. Bayart explains that Mononttoya wasn't acting because of Ms. Crotty. Ms. Crotty never made Ms. Mononttoya do anything. Therefore, Ms. Crotty shouldn't be held accountable for what Ms. Mononttoya went out and did of their own accord. Finally, you'll hear from Miss Crotty herself, who'll explain to you that Remy and her aren't close, and that Remy took things way too far, and Miss Crotty never expected them to break into Marshek's house and steal. The prosecution would like to convince you that Miss Crotty made Miss Mononttoya do this, and that Miss Crotty incited her actions. But you'll see that that's simply not the case. We will see throughout this trial that there is in fact a reasonable doubt that Miss Crotty did not aid and abet first-degree burglary and was not an accessory after the fact. All of the evidence that the prosecution brings is circumstantial, and the rules state that when there are two paths, one that leads to guilt and one that does not, the judge must rule that the defendant is innocent. Therefore, at the end of this trial, Your Honor, we will ask you to find Lee Crotty not guilty on all charges. Thank you.
Thank you very much. Opening statements have been completed. The prosecution will call their witnesses. Is the prosecution ready to call its first witness?
Yes, Your Honor. The prosecution would like to call Officer Max Bird to the stand.
Officer Max Bird, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes.
Thank you.
And for the convenience of the court, my name is Lilette Edwards, and this witness's statement can be found on pages 29 to 31 of the mock trial case packet. May I begin?
Yes, please.
Where are you employed?
I've been an officer with the Beacon County Sheriff's Station for just under a decade.
What happened on the afternoon of February 15th?
On February 15th at 3:12 p.m., the station received a call from Drew Marshek stating that he had been robbed. I was deployed to the scene where I found evidence of a break-in and Marshek suffering a head injury.
What did you do next?
I talked to Marshek, who gave me a description of the perpetrator and told me that they had taken a briefcase. The police sketch and footage of the suspect from Marshek's security camera were aired on local news, and an all points bulletin with a photograph was sent out.
What happened on the morning of February 16th?
At 9:34 a.m., dispatch received a tip about a person matching the suspect's description. I immediately went to the address from the tip.
And what happened when you arrived at that address?
When I arrived, an individual matching the suspect's description was pacing in front of the yard. I approached carefully, announcing myself and showing my badge as I was not in uniform. Based on the photographs, I identified the suspect as Remy Mononttoya.
Did Mononttoya say anything to you at that time?
Yes, I believe Mononttoya began talking about government lies. As I placed Mononttoya in the back of the officer's car, Mononttoya told me that we are starting a revolution here, asking me to join us, nodding towards the house at the same time.
Objection, Your Honor. This testimony is hearsay. Move to strike.
Response?
Your Honor, may I be heard?
Yes.
This is not offered for the truth of the matter, but to explain the officer's actions, why the officer considered Lee Crotty to be a witness.
Anything further regarding? I'm sorry to interrupt you. Go ahead.
Never mind.
No, that's all right. Did you have anything else to add?
Well, yes. I would say that even if it were hearsay, it would be an excited utterance, but that's not even relevant because it is not hearsay. It's not offered for the truth.
Thank you. Anything further regarding your objection, please?
Nothing. Thank you, Your Honor.
I'm going to accept the testimony for the constrained purpose outlined by the questioning counsel. So in that regard, I'll respectfully overrule and allow the question, and I'll allow the response. Next question, please.
Thank you, Your Honor. Did you have any reaction to Mononttoya's outburst?
I realized that us must mean Mononttoya and whomever else might be in the house.
And what happened next?
The defendant, Lee Crotty, rushed out of the house, clearly distressed. Crotty immediately asked me, "Oh God, what did Remy do? What did Remy take?"
Had you had any prior conversation with the defendant at that time?
No, ma'am, I had not. It was only after Crotty's question that I identified myself and told Crotty that Mononttoya had been arrested for burglary and assault.
Did you take a statement from the defendant?
Yes, I took a statement from Crotty. He told me who Mononttoya was and how Remy Mononttoya came to be at her house. Crotty seemed nervous and repeatedly asked me what was going to happen to Mononttoya.
And then what did you do?
At my request, Crotty showed me the room Mononttoya had spent the night in. Crotty then accompanied me down to the station for further questioning.
Did anything of significance happen on your way to the station?
Yes. In the car, I recognized Crotty from a clip from their YouTube channel. The topic of the video clips being used by anarchists came up, and Crotty immediately grew defensive and brought up Mononttoya, asking if I thought what Mononttoya did was Crotty's fault.
And did the defendant say anything else?
Yes, ma'am. At the time, I did not suspect Crotty of anything. I tried to explain that, but Crotty interrupted me, saying that that she told the kid to go down there and get those documents. Crotty also said that she knew Mononttoya could be aggressive and is passionate about the cause.
Objection, Your Honor. This testimony is also hearsay. Move to strike.
Response, please, as to the hearsay objection.
This is also not for the truth of the matter, but to show the defendant was aware of the significance of his actions and that he knew the defendant, or pardon me, that he knew Ms. Mononttoya had a tendency to be violent.
Anything further regarding your hearsay objection, please?
I would argue that it is for the truth of the matter, as the hearsay is, I told the kid to go down there.
Then, Your Honor, may I be heard?
Yes.
This is also hearsay exception M, admission by a party opponent.
Anything further as to the exception, please?
From the
Counsel for the objecting party.
Oh, nothing, Your Honor. Thank you.
That's all right. Thank you. I'll accept it for that limited purpose, and I'll find that the exception does qualify. So I'll allow the question to stand. I'll allow the response to stand. Your next question, please.
Thank you. Had you at any point informed the defendant what Remy Mononttoya was accused of stealing?
No, ma'am. I would never reveal details of an ongoing investigation without prior approval.
What happened after that?
Crotty was questioned at the station, and Remy Mononttoya was questioned as well. I interviewed Mononttoya again, as well as Zuri O'Neal, another member of the group chat, and Aaron Sullivan, Crotty's agent.
And what did you do next?
Based on the information I gathered from the witnesses, I obtained an arrest warrant for Lee Crotty. On February 23rd, I returned to Crotty's house and placed Crotty under arrest for aiding and abetting, first-degree burglary, and accessory after the fact.
Thank you. No further questions at this time.
Cross-examination, please.
Yes, Your Honor. For the convenience of the court, my name is Molly Tatum. You received a tip from someone who recognized the suspect, Remy Mononttoya, on the morning of February 16th, correct?
Yes, that is correct.
And you went to this location?
Yes.
But you weren't called to the location, were you?
No, I went there because
Objection,
of the tip
Your
I
Honor.
received.
What's the
Objection, Your
objection,
Honor.
please? Go ahead.
Relevance. This has no relevance. The officer went to the address because officers are supposed to respond to tips like that. It has nothing to do with the case at hand.
Response to the relevance objection, please.
I would argue that it is relevant because Officer Max Bird assumed the suspect was armed and dangerous by going to a location that he was not called to.
Objections overruled. Answer will stand. Next question, please.
Thank you. And when you got to this location, you placed Remy Mononttoya under arrest, didn't you?
Yes.
And when Ms. Crotty came out of their house, their first reaction to seeing you was shock and confusion, right?
Yes, they certainly seemed shocked. However, that is not abnormal if you see someone getting arrested on your front lawn.
And after that, you asked Ms. Crotty a few questions, right?
Correct.
And then Ms. Crotty proceeded to show you where Remy had slept that last night?
Yes.
And all the while, Ms. Crotty was completely cooperative and willing to help you at every turn, right?
Yeah, she showed me the guest room that Crotty had spent Mononttoya had spent the night in.
And then you were driving Ms. Crotty to the station. And during that drive, a conversation about Ms. Crotty's video clips and social media presence came up, right?
Yes.
And during this conversation, you mentioned that Ms. Crotty's clips were used by anarchists?
Yes, that her clips had been used by anarchists and some people were using her as a representative for anarchist views.
But only after you mentioned anarchists did Ms. Crotty seem to get defensive at all, yes?
Yes, after I mentioned her clips being used by anarchists, she shifted the topic over to what Mononttoya had done.
Officer Burt, let me bring your attention to Exhibit A. Can you please identify this exhibit?
Yes, I believe Exhibit A was the text messages between Montoya and the group chat, correct?
I apologize. No, it's on page 46.
Oh, yes, let me open that up. Page 46. Oh, yes. Exhibit A is Drew Marshek's briefcase.
Yes, and you never saw the defendant, Miss Crotty, with this briefcase, did you?
No, at no point did I see Miss Crotty with this briefcase.
Your Honor, may Exhibit A be turned into evidence?
It is.
Thank you.
Thank
No
you.
further questions.
Any redirect regarding this witness, please?
No redirect at this time. May this witness please be excused?
Yes, thank you very much for your testimony. If the prosecution could please call its next witness.
Yes, Your Honor, the prosecution would like to call Drew Marshek to the stand.
Drew Marshek, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, I do.
Thank you.
Before I proceed, the prosecution would like to request a time check for both direct examination and closing statements.
Prosecution has 10 minutes and 17 seconds remaining for direct examination and 5 minutes and 37 seconds remaining for the closing statement.
Thank you. For the convenience of the court, my name is Mira Narayan, and this witness's statement can be found on pages 27 to 28 of the case packet. May I begin?
Yes.
Good evening, Mr. Marshek. Could you please introduce yourself to the court?
Yes, my name is Drew Marshek.
And what is your occupation?
I've been an investigator with the California State Department of Justice Bureau for over 15 years now.
What does your work for the Bureau of Investigation entail?
In general, involves a collection and analysis of time-sensitive material, but I can't go into much detail because of that.
Now, referring your attention to Exhibit A, which has been pre-marked for identification, can you identify this item?
Yes, this is my state-issued briefcase. It is clearly marked with my name and insignia of the Justice Bureau.
Now, did anything unusual happen on February 15th, 2020?
Well, yes, I was attacked and robbed.
By who?
I did not know it at the time, but I later learned the intruder was Remy Mononttoya. I saw her inside my home holding my briefcase, and when I tried to stop her, Remy punched me in the face and I hit my head and lost my balance on the edge of the table. Sorry about that.
Did Remy Mononttoya say anything at that time?
Yes, she was panicking. I heard her say, Leah's not going to like this, and at least we got the proof we needed before running out and saying, I'm sorry, I had to do this for the people.
Objection, Your Honor. This testimony is hearsay. Move to strike.
Response as to the objection and the motion, please.
Yes, Your Honor. This statement falls under hearsay exception state of mind, as it goes to show what Remy Mononttoya was thinking at the time.
Objecting counsel's response in relationship to the asserted hearsay objection, please.
None, Your Honor. Thank you.
I'll respectfully overrule the objection, allow the answer to stand. Next question, please.
I have no further questions at this time, Your Honor.
Thank you. Cross-examination, please.
Yes, Your Honor. For the convenience of the court, my name is Molly Tatum. Good evening, Mr. Marshek. You returned home from a grocery shopping trip on February 15th, correct?
Yes, that is correct.
And when you walked into your house, you noticed muddy footprints on the floor, didn't you?
Yes, I did.
But you didn't call the police at this time.
No, I did not, because I was curious as to what happened.
And when you walked into your house, you saw Remy Mononttoya, right?
Yes, I did. I did see her.
And you didn't try to reason with Mononttoya or talk to Mononttoya at all, did you?
No, I did not. I didn't really have the time for that. She was kind of right in front of me. I didn't have the words for it.
So you immediately resorted to using physical force to stop Mononttoya, didn't you?
I would say yes.
And only then did Mononttoya retaliate.
I would say somewhat, yes, that is correct.
And during your interaction with Mononttoya, they seemed excessively panicked, right?
Well, yes, they were attacking and robbing a house, so I presume, yes, they were.
And after this, Mononttoya left your house, yes?
Yes, she did.
And then you called the police?
Yes, I did, after I hit my head.
Thank you. No further questions.
Anything further of this witness, please?
Nothing further, Your Honor. May this witness please be excused?
Yes. Prosecution's next witness.
Yes, Your Honor. The prosecution would like to call Dr. Kai Chavez to the stand.
Dr. Kai Chavez, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
Dr. Chavez, what is your occupation?
I work with patients with various psychiatric illnesses, and then I prescribe them the necessary medications along with psychotherapy.
And have you ever been qualified as an expert witness?
I've been qualified as an expert witness approximately 150 times.
Now, what is your involvement in this case?
I was asked to offer my expert opinion regarding Lee Crotty's influence over Ms. Montoya's actions. To reach this opinion, I have reviewed all witness statements, exhibits, and Dr. Bayart's report.
Were you able to reach a conclusion?
Remy Mononttoya would not have acted independently to assault the victim or burglarize his home had she not been directed to by the defendant.
How did you come to that conclusion?
Based on the evidence, it can be seen that Lee Crotty created a toxic environment that fostered a mode of thinking called groupthink.
Could you explain what groupthink is to the court?
The idea governing groupthink is that a group acts in certain inflexible ways that leave little room for individual creativity or decision-making. Essentially, the group agrees for the sake of agreeing. An environment of conformity is promoted as opposed to individualized thinking, and disaster can result.
How would groupthink apply to an online situation like this one?
In an online setting, groupthink is often associated with the idolizing of an online personality. Cyberbullying and doxing can occur when the online leader targets someone and then their followers follow their lead. The way the established fan group acts quickly becomes a reflection of the online environment created by the idolized leader, like a celebrity or a public figure.
And could you explain what doxing is to the court?
Doxing is revealing someone's personal identifying information online. Lee Crotty doxed Drew Marshek.
Now, did you find any evidence of this groupthink phenomenon in this case?
Yes. Based on my examination of the evidence, it is clear that Lee Crotty was the leader of this group, and the group followed patterns of groupthink.
Referring your attention to exhibits B and C, could you explain how groupthink is shown?
The language used in Exhibit B, and in particular Exhibit C, is very telling. Crotty's repeated use of exclamation points in all capital letters is intended to emphasize her authority and produce a certain course of action, as well as words like demand and take. Crotty's specific direction to Remy Mononttoya is to get into Drew Marshek's house and get the documents that Lee sought.
Are specific directions like this harmful?
In a toxic environment, direct calls for action can promote toxic behavior. Lee Crotty created a toxic environment with the group chat of which she was the leader.
Thank you. No further questions at this time.
Cross-examination, please.
Yes, Your Honor. For the convenience of the court, my name's Ayanna Bush. You said that groupthink can embolden individualized ideas, didn't you?
Yes, that is one of the parts that makes groupthink so dangerous.
At the same time, groupthink leaves little room for individual creativity. Yes or no?
Yes, it is one of the things that creates an environment of conformity.
And calls for actions are not by themselves toxic. Those were your words, yes?
Yes, but within an environment, calls for actions can then promote toxic behavior, such as assault and burglary.
And Miss Crotty texted Miss Mononttoya in a private WhatsApp conversation outside of the group chat to ask Miss Mononttoya to get the documents, correct?
Yes, but Miss Mononttoya had at that point already been influenced by the ideas that were introduced within the group chat, and then they were only taken further in the private chat.
You said Miss Mononttoya participated in groupthink, yes?
Yes, she was in that group chat that showed groupthink.
And the group chat Miss Crotty accidentally sent Marshek's uncensored address to included not just Miss Mononttoya, but 6 of Miss Crotty's most loyal fans, didn't it?
Yes, but Remy Mononttoya was the only person that then got the private directions from Lee to go demand and take the documents. Or sorry, to go to Marshek's house and get the documents.
But the only one who explicitly, individually robbed the house was Remy Mononttoya, yes?
Yes, but she was still the only one that received that specific direction.
Well, then that would mean it can't be ruled out that Miss Mononttoya may have acted on their own, and not because of groupthink, doesn't it?
It cannot be ruled out, but it is my expert opinion that she was influenced by Lee Crotty, especially in that private chat.
Thank you. No further questions, Your Honor.
Thank you. Anything further of this witness, please?
Nothing further, Your Honor. May this witness please be excused?
Yes, thank you. Any other witnesses on behalf of the prosecution?
Yes, Your Honor. The prosecution would like to call Remy Mononttoya to the stand.
Remy Mononttoya, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, I do.
Thank you.
And for the convenience of the court, my name is Nariana Bretholtz, and this witness's testimony can be found on pages 23 through 26 of the case booklet. May I begin, Your Honor?
Yes.
Thank you. Now, Ms. Mononttoya, would you please state your name and employment for the court?
Yes, good evening. My name is Remy Mononttoya. I'm 21 years old. I work as a sales associate at Thinker Toy Corporation. I also attend Beacon Hills Community College.
Now, when did you first learn of the defendant, Lee Crotty?
I first discovered Lee's videos in November of 2018. I then started to follow Lee on YouTube.
And what happened in March of 2019?
In March of 2019, I received my first direct message from Lee, inviting me to join a private chat with other followers.
And after joining this group chat, how often did you interact with Lee?
Lee and I interacted directly 2 to 3 times a week, and indirectly through chats, comments, and likes.
Now, what happened on the day of February 11th, 2020?
I saw that Lee had posted about a new video that he was planning on releasing the coming Thursday about government secrets.
Then what happened?
Then the next day, Lee sent a message to the group chat I was in with a sneak peek of the video that he was going to release on Thursday.
And showing you what has been pre-marked as People's Exhibit B. Do you recognize this?
Yes, this is a transcript of the group chat on February the 12th.
What did Lee say?
Lee told us that he had been given official documents proving the existence of aliens, and told us to go to the person who had wrote the report, this guy named Marshek, and demand answers, and take the documents if Marshek wouldn't answer us.
What happened on Thursday, February the 13th?
On Thursday, Lee released the full video on RCN.
Did Lee ask anything of his followers during the video?
Yes, he did. In the video, Lee told us to get down to where this official lives and demand answers.
And did you know where Mr. Marshek lived?
Yes, I did, because Lee had included Marshek's address in the sneak peek.
Turning your attention to what has been pre-marked as People's Exhibit C, do you recognize these texts?
Yes, these are the messages that Lee and I exchanged directly on February 14th.
What did Lee ask of you?
Lee told me that he needed me to go, or she needed me to go to Marshek's house to get the documents before the meet and greet. She said that we really needed those documents and that I needed to get into that house. I knew that I had to do it by any means necessary. Lee was counting on me, and I didn't want to disappoint her.
Now, turning your attention to Saturday, February 15th, what happened?
That was the day that I went to Marshek's house. I took a briefcase and other documents that Lee wanted, but on my way out, I got caught and I completely panicked. I punched Marshek in the face and I ran.
Showing you what has been pre-marked as People's Exhibit A, can you identify this?
Yes, it's a photo of the briefcase I took.
Now, Ms. Mononttoya, what did you do next?
Lee and I already had a plan set up to meet each other at the meet and greet, so I took the briefcase and all the other stuff I got there.
Did you speak to Miss Crotty?
Yes, I told her that I got the stuff that she wanted from Marshek's house, but that the plan had gone really wrong when Marshek caught me in the house.
And how did the defendant react when you told her that?
Lee looked really concerned and had me wait in the cafe until the event was over.
Then what happened?
Then Lee took me to her house and let me stay there. I needed to hide in case I was being followed.
And after that, what happened?
I pleaded with Lee to let me lie low at her place until I was certain I wasn't being followed. So Lee let me stay the night in her guest house.
Did you speak to Lee Crotty the next day?
No, I wasn't able to. I was waiting in the front yard for Lee to get up, but I was caught before.
2 minutes.
Now, finally, Miss Montoya, would you have gone to Marshek's house if Lee had not directed you?
No, I would not.
Thank you. Your Honor, no further questions at this time.
Thank you. Cross-examination, please.
Yes, Your Honor. And for the convenience of the court, my name is Michelle Aguilar-Moore. May I begin?
Yes.
Good evening, Miss Montoya.
Good evening.
You're a loyal follower of Lee Crotty's YouTube channel, The Right Choice of News, correct?
Yes, I would say so.
And in March of 2019, Lee Crotty invited you to a private group chat, is that right?
That's correct, yes.
And on February 12th, Crotty sent your group chat a short clip preview regarding the videos they were planning to post about government secrets, is that right?
Yes, that's correct.
And in the documents Ms. Crotty was holding in the video, you saw what appeared to be Drew Marshek's address, correct?
That's
Objection,
correct.
Your Honor. Lack of foundation for the documents.
Response as to the lack of foundation objection, please.
Your Honor, in the previous question, I did lay foundation speaking about the video that I later asked about in the following question.
Anything further regarding your objection as to lack of foundation?
Yes, Your Honor. Regarding the video, foundation has been laid, but there has been no foundation laid for the documents that counsel is bringing up.
Focusing on the foundation objection as it relates to the documents. Response on behalf of inquiring counsel, please.
None, Your Honor.
I'll sustain. Next question, please.
And you saw in the video that Lee was holding documents, is that right?
That's correct, yes.
And in the documents Lee was holding in the video, you saw what appeared to be Drew Marshek's address, correct?
Yes, that's correct.
So you made the decision to write down Marshek's address information.
Yes, I thought that Lee included it in the video, so it must have been some importance. I figured I could write it down.
And you said you did this because this was Lee's way of calling you to action. Those were your words, is that right?
Yes, I figured that what Lee must have done must have had some significance. She wouldn't have done it otherwise.
Thank you. But you also said that no next steps were specified by Lee during this call to action. Is that correct?
Not during that exact call to action, but later Lee reached out to me and asked me to go to Marshek's house and get the documents. So yes, I would say that there were steps later.
But at this time, no next steps were specified during this call to action, yes or no?
No, not at that exact time.
So really, this call to action was nothing more than an assumption by you, is that right?
I wouldn't say so, no, because Lee followed up with me afterward and asked me to go to Marshek's house and get the documents.
Right, but at this time, since no next steps were specified during this specific time, this call to action was nothing more than an assumption by you, yes or no?
It was a conclusion, Your Honor.
Asked and
I'm
answered.
sorry, what was the objection?
Asked and answered, Your Honor.
I'll respectfully overrule. Go ahead and ask the question one more
Thank you,
time.
Your Honor.
This call to action was nothing more than an assumption by you during this time, is that right?
It was a conclusion that I made based on reasonable evidence that later proved itself to be true.
Thank you. And 2 days after, Ms. Crotty asked you to go to Marshek's house to retrieve the documents, is that right?
Yes, that's correct. Lee reached out to me directly and asked me to get the documents by any
And based on this conversation, you said you had to get the documents by any means necessary. Those were your words, is that right?
Yes, because that's what Lee had implied. She made it very clear that we needed those documents under
2 minutes. Thank you. But Crotty never told you to get the documents by any means necessary, is that right?
No, Crotty never used those exact words, but her tone implied that we really needed those documents.
And
so I think that
And on Saturday, February 15th, you went to Marshek's house and you broke into their house, is that right?
Yes, that's correct, I did.
And before leaving the house, you encountered Marshek?
Yes, that was not part of the plan.
And then you punched them in the face.
Yes, again, not part of the plan and not something I'm proud of, but I was overwhelmed and it happened.
But you said you did this out of panic. Those were your words, yes or no?
Yes, that's correct. I think that anyone in a situation like that would have been reasonably panicked. I agree that what I did was wrong.
Objection, Your Honor. I'm asking a simple yes or no question, and this witness is being non-responsive and lapsing into a narrative.
So what are you asking for? You want
I'm
me to
objecting.
strike part of the response? I'm sorry?
Yes, Your Honor, and yes.
All right. I'll respectfully deny. I'll allow the entire answer to stand. What's the next question, please?
Thank you. And you went to the meet and greet to tell Ms. Crotty what had just occurred, is that right?
Yes, we already had a plan to meet and greet, so I just went there and I told Lee more or less what happened.
And the only reason you were sure you got your message across to Lee about the crime you had just committed was because Lee looked genuinely concerned. A yes or no answer, please.
I remember, yes, well, sort of. I remember telling Lee what had
30
occurred,
seconds.
so I don't remember the specifics.
So is the answer to my previous question yes?
Yes, more or less.
And on the car ride back to Crotty's house, you kicked Drew Marshek's briefcase that you had?
Yes, I was frustrated and had been through a lot that day.
And Crotty asked you if the briefcase was a prop, correct?
Yes, that's correct. I was very confused, but I kind of brushed it off.
So just to be completely clear, did Lee Crotty ever explicitly ask you to commit burglary?
Stop. Objection, Your Honor.
Stop.
Yeah, I think we have to stop at this point. So anything further of this witness from the prosecution?
None, Your Honor. May this witness please be excused.
Yes.
Thank you. Then at this time, the prosecution rests, Your Honor.
Prosecution rests, so the case will turn to the defense. And if the defense is indeed ready to proceed, please call your first witness.
The defense would like to mark exhibits A and C for inspection first, Your Honor.
Any objection to marking those?
None, Your Honor.
Thank you.
The defense would like to call witness Aaron Sullivan to the stand.
Aaron Sullivan, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, I do.
Thank you.
For the convenience of the court, my name's Ayana Bush.
For the convenience of the court, my name is Zora Martinette Tamati.
Please state your name and occupation.
My name is Aaron Sullivan, and I'm Lee Crotty's agent.
Your agent? What do you do for that?
I help set up events, schedule appearances, act as liaison with Lee's publicist, and work on the legal and business sides of Lee's brand.
What do you do on the legal side of Miss Crotty's brand?
I make sure that whenever Lee is going to do something, like directly ask for action from their followers, it's cleared legally and cannot implicate them in any legal issues.
Does Miss Crotty typically follow the advice of you and the legal team?
Of course they do. Lee rarely takes any action without first talking to me and the legal team.
What's an example of this?
The legal team encouraged Lee to put a disclaimer at the beginning of each video to outline its intent and to warn potentially younger viewers of its sensitivity.
What did that disclaimer say?
It said, "This video discusses topics and news that may be disturbing to some viewers. It may include images that are more graphic in nature. The purpose of this video is for education and discussion only."
And would most viewers see this disclaimer if they were watching one of Miss Crotty's videos?
Oh, definitely. It's right at the beginning. You can't miss it.
What is one of the things you've advised Miss Crotty to do for their brand in the past?
We created a series of private group chats on Twitter with some of Lee's most loyal followers.
How did that affect the channel?
Lee's engagement went up. Some of Lee's videos were starting to hit 7-figure view counts. Lee was making it on the YouTube trending page and was starting to book more interviews and collaborations.
How did this affect Miss Crotty's relationship with their fans?
By making the followers in these group chats feel like Lee was more connected to them, it basically resulted in free advertising for their brand.
On the day of the meet and greet, did you recognize Remy Mononttoya?
I remember Lee mentioned a conversation between them and Remy. It sounded pretty typical of Lee, the type of thing that makes him a good client for me, very edgy.
How did Miss Crotty act around Remy Mononttoya on the day of the meet and greet?
Lee showed Remy to a table nearby and asked me to keep an eye on them for the rest of the event.
Why would Miss Crotty want you to keep an eye on Miss Mononttoya?
Lee always looks out for their fans. Several times during similar events, I've seen Lee go above and beyond for their fans, acting more as a friend than an internet celebrity.
Do you believe Miss Crotty would ever encourage something like burglary?
I know Lee is innocent. Lee would never do anything to jeopardize their brand.
No further questions, Your Honor.
Cross-examination, please.
Yes, Your Honor. May I begin?
Yes.
And for the convenience of the court, my name is Lolette Edwards. You make your living as an agent, correct?
Yes.
The defendant did not consult you before sending the video sneak peek containing Drew Marshek's personal information to Remy's group chat?
I can't answer this question. It would require my own speculation.
Objection, Your Honor. This information is beyond the scope of the statement of facts. Ms. Sullivan cannot testify to this.
I think
Your
that's
Honor, may I
just.
be heard?
I think that's just what she said. But if you want to be heard regarding the question, that's fine. Go ahead.
This is certainly not beyond the statement of facts because it is very significant to this case and would most certainly have been mentioned in the packet at some point if it were not the case, or pardon me, if the witness had been consulted.
I'm going to allow the question and the response to stand, and you're welcome to follow up on this.
Thank you. Did you have a chance to answer?
No, I don't know the answer.
Whether you were consulted. You do not know whether you were consulted?
It's not in my statement, so I don't know.
You have no idea whether do you have any memory of a sneak peek from a video being sent to a group chat by your client?
Objection, Your Honor. Ms. Sullivan cannot answer to this. Ms. Sullivan directed Ms. Crotty to create these group chats, but was not a part of these group chats.
So let's make sure we do a legal objection. What's your legal objection?
An unfair extrapolation, Your Honor.
What's the response regarding unfair extrapolation?
This is exactly the same answer as the answer to the previous question. It's most certainly relevant and certainly would have been mentioned in the packet were it the case that this witness had seen that group chat.
May I respond, Your Honor?
Yes.
I did not object to irrelevance. I objected to the fact that Ms. Sullivan is not able to testify to this as she was not part of the group chats.
In relationship to an unfair extrapolation, does inquiring counsel wish to refer to her statement, a page and line as to where this exists?
Your Honor, it is not, in fact, in the packet. However, it is a very fair extrapolation because it would most certainly have been mentioned if this witness had seen it.
All right, I'm going to find.
Not,
I'm sorry, go ahead.
The fact that it was not mentioned makes it very clear that this witness never did see it. It is stipulated that this witness has not reviewed every exhibit.
All right, so noted. I'm not going to find that there's an unfair extrapolation. I'm going to allow the question to stand, the response to stand. And what's your next question, please?
Thank you, Your Honor. May I continue?
Yes.
But you were not aware that the defendant directly told Remy, you need to get into Drew Marshek's house and get the rest of the documents?
Lee mentioned a WhatsApp conversation, but I didn't know the exact wording of what transpired there.
Thank you. When you saw Miss Mononttoya at the meet and greet, you assumed Lee knew this person quite well?
Yes, I assumed.
And you observed the defendant's reactions were not the same as with other fans, correct?
Yes, Remy seemed quite frazzled.
In speaking to you, the defendant referred to Miss Mononttoya as my friend Remy?
Yes.
Thank you, Your Honor. No further questions.
Thank you. Anything further of this witness?
Yes, Your Honor. The defense would like to ask the witness some redirect questions.
That's fine. Please proceed.
What, if anything, would Miss Crotty never encourage if their brand were at stake?
Lee would never encourage anything illegal.
Objection, Your Honor. This is outside the scope of cross-examination.
Response as to outside the scope, please.
Your Honor, This question covers the issues brought up in the cross-examination, as the counsel had brought up to Ms. Sullivan the text between Ms. Crotty and Ms. Montoya concerning on certain instructions on committing an illegal action.
All right. Anything further from the objecting counsel's perspective?
Yes, I did not ask this witness any question about whether or not the defendant would, in fact, ask someone to commit an illegal action.
The objection is sustained. The answer is stricken. Next question, please.
No further questions, Your Honor. May the witness
Thank
be
you.
excused?
Yes, thank you very much. Next witness, please.
The defense wishes to call Zuri O'Neal to the stand.
Zuri O'Neal, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
Hello, Ms. O'Neal. Will you please state your name, age, and occupation for the court?
My name is Zuri O'Neal. I'm 18 years old, and I am an intern at Atlantis News Nightly.
And how do you know Ms. Crotty?
I started following Lee's YouTube account in August of 2018, and then followed Lee's social media a month later.
When did you first communicate with Ms. Crotty?
In March of 2019, Lee created a group chat with some of Lee's other followers. Since then, we would interact about 2 to 3 times a week.
And what usually went on in these group chats?
Lee would show sneak peeks of videos or talk about upcoming brand deals. It was also a place for debate and venting about the issues that Lee talked about.
And what were the debates in the group chat like?
Well, they could get a little heated, but that was only because we were so passionate about the issues. It was really just a stress-relieving place to vent. The group chats were harmless.
Did Ms. Crotty send anything to the group chat?
Yes, on February 12th at around 2, Lee sent out a video saying that the government was hiding evidence of aliens, which I watched immediately.
And Montoya was on these group chats, and Montoya was the only one out of all the members who committed a crime, correct?
Yes.
When did you next have contact with Ms. Crotty?
I saw Lee at the meet and greet on Saturday.
And how did you learn that Ms. Crotty and Montoya had been arrested?
I found out on Twitter, and it is clear that the government is just trying to suppress people who question their power.
Thank you. No further questions.
Cross-examination, please.
Yes, Your Honor. And for the convenience of the court, my name is Mira Narayan. May I begin? Ms. O'Neal?
Yes. Sorry, I had to unmute there. Yes.
Well, I apologize. Before I begin, the prosecution would like to request a time check for cross-examination.
The prosecution has 8 minutes and 44 seconds remaining for cross-examination.
Thank you. Ms. O'Neal, you started watching Lee Crotty because you don't trust the government, correct?
Well, actually, I started watching Lee because of my job, and then I started following and watching Lee because of personal interest.
Thank you. And you have direct contact with Lee often, correct?
Yes, me in that group chat 2 to 3 times a week.
So you would say that you know the defendant pretty well, correct?
I'd say we're all pretty friendly, yes.
Now, you said that the defendant doesn't beat around the bush, isn't that right?
Yes.
So when the defendant says something, it is your experience that she means it?
Yes.
More specifically, you said that there is no subtext or hidden meaning, correct?
Objection, Your Honor. This question calls for opinion testimony.
Response as to the objection that this is improper opinion?
Your Honor, the witness has already answered the question that when the defendant says something, it is her experience that she means it. I'm simply clarifying that statement.
Anything further by the objecting attorney?
No, thank you, Your Honor.
I'll overrule the objection, allow the question and answer to stand. Next question, please.
Lee never says anything in private that Lee would not wholeheartedly stand by in public, correct?
Yes.
And the defendant did say to get down to where this official lives if necessary and demand answers, correct?
That is correct, but in the group chat, it may look rash or revolutionary, but it is really just venting among friends.
Thank you. But she did say that if Marshek won't answer us, we'll take what is ours, correct?
Yes, but again, rash and revolutionary on the outside.
The defendant did not say, if Marshek won't answer us, we'll take what is ours in a nonviolent and peaceful manner, correct?
Sure, but they didn't say in a violent manner.
But the defendant did not suggest other legal ways to compel the government to release information?
No.
Thank you. No further questions.
Anything further of this witness?
Sorry. Yes, Your Honor. Permission to begin?
Please proceed.
Ms. O'Neal, tell us again, what were the group chats with Ms. Crotty like?
As I've said before, they were a place for passionate debate and venting, but nothing more.
Objection, Your Honor. This is outside the scope of cross-examination. I did not ask about what the group chats were for.
Response as to outside the scope, please.
I would argue that yes, you discussed the group chats and what went on inside of them, and so it would be fair for me to ask a question about the contents of them.
I'm going to overrule the objection, allow the response to stand. Next question, please.
That will be all, Your Honor. No further questions. May this witness be excused?
Yes, thank you very much. Next witness, please.
The defense would like to call Dr. Jess Bayart to the stand.
Dr. Jess Bayart, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes.
Thank you.
For the convenience of the court, my name's Ayanna Bush.
For the convenience of the court, my name is Karina Bunch.
Please state your name and occupation.
My name is Dr. Jess Bayart, and I am an associate professor of sociology at Beechwood University.
What are your qualifications?
I have a PhD in sociology from Peterson University, focusing on activism and social movements.
What are some of your accomplishments?
I have written multiple articles on social movements, and I've had my work published in the New York Times, the Wall Street Journal, and other publications.
The New York Times? Congratulations. What's something you've published?
I wrote an article about how social movements had to switch online due to the coronavirus pandemic. I researched what made these movements successfully switch to social media and found that most effective movements were led by youth and young adults.
Based on your studies, what effect can influencers have on social movements?
Influencers can act as a catalyst for a movement, but not necessarily the leader of the organization that will direct their actions. Lee Crotty is this type of activist.
Can you elaborate on what role Ms. Crotty takes on social media?
Lee seeks to inspire others to take action without participating in those actions. These communications with fans are consistently framed as a way of getting information out into the world, not taking illegal action.
You mentioned social movements are most successful when led by young people. Why is this?
Generation Z has grown up with social media as a primary facet for their social development. Young people, like Remy Mononttoya, are inspired to not only participate in, but often lead movements.
How does Ms. Montoya's use of social media connect to this?
Remy's interactions with Lee are pretty typical of how social movements begin online before carrying over into the in-person world. They often grow out of fan bases who idolize an online personality.
What are some typical behaviors in fan bases?
Gen Z fans have the ability to act autonomously from their idols, and their actions are almost never prompted by the person that they idolize.
After looking at the conversations between Ms. Crotty and Ms. Mononttoya, is it aligned with these normal behaviors?
It appears that Remy is the type of activist who would act independently of a political influencer like Lee in pursuit of shared political goals.
What's an example of how Ms. Mononttoya has acted independently?
Well, Lee might have texted Remy about acquiring the documents, but it was Remy, not Lee, who took action and decided to rob the house.
In your professional opinion, were Ms. Montoya's actions separate from their passion for Ms. Crotty?
In my professional opinion, Remy acted independently of Lee's influence, separating Remy's adoration of Lee from the reality of their actions.
No further questions, Your Honor.
Cross-examination, please.
Yes, Your Honor. And again, for the convenience of the court, my name is Mira Narayan. May I begin?
Yes.
Dr. Bayart, your field is focused on major social movements, correct?
Yes, it is.
It is not focused on direct interactions between individuals.
No, I focus on social movements and activism.
Thank you. Now, would you say that Remy Mononttoya was a hardcore fan of Lee Crotty?
Yes, Remy's was what you call a stan of Lee, and their actions online were pretty consistent with the level of involvement of most typical Gen Z stans.
Thank you. And the defendant does want to use her fan base to support her movement, correct?
Yes, she hopes to inspire them to take individual action.
Thank you. Now, referring your attention to Exhibit C, the transcript of the February 12th group chat, the defendant specifically noted that the author of the report left his name on it, correct?
Yes, that is correct.
So you would agree that if not for Lee Crotty, Mononttoya would not have had the information needed to burglarize Drew Marshek's house?
Yes, but again, Lee's intentions were just to inspire the participants in their YouTube channel to take independent action.
Thank you. The defendant also says if Marshek won't answer us, we'll just take what is ours, correct?
Yes, Lee is a passionate YouTuber with a cause that they want to support.
Thank you. Now, directing your attention to Exhibit C, this is a private text conversation between just Lee Crotty and Remy Mononttoya.
Yes, it is.
And in this conversation, Lee Crotty directs Remy Mononttoya to go to Drew Marshek's house because it is near where Remy is?
Yes.
Would you consider this kind of direct contact typical behavior of an online influencer?
Online influencers like Lee just want to act as a catalyst for movements, whether that is through whatever actions that is. They hope to inspire others.
Thank you. The defendant again reinforces what she wants Remy Mononttoya to do. We need those documents, Remy. Really need them. You need to get into that house tomorrow, correct?
Yes, again, Lee is very passionate about her cause.
Thank you. But it is still your opinion that without Lee Crotty texting Remy specific instructions to get into the house and get the documents, Remy would have simply done it anyway?
There is no knowledge of what Remy would have done with or without Lee's influence. It is just Lee wants to help get the word out about their cause.
But this is your opinion, yes or no?
My professional opinion, yes.
Thank you. No further questions.
Anything further of this witness, please?
Yes, Your Honor. Dr. Bayart, was Remy Mononttoya the only one in this group chat which Ms. Crotty sent the uncensored address to?
No, there was 6 other people in this group chat.
Thank you. No further questions.
Ready to excuse this witness?
Apologies. Yes, Your Honor.
That's fine. That's all right. So this witness is excused. Next witness on behalf of the defense, please.
Yes, Your Honor. The defense would like to call Lee Crotty to the stand.
Lee Crotty, please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
And at this time, Your Honor, the defense would also like to ask for a time check on direct examinations.
The prosecution as well, Your Honor, for cross-examination. Thank you.
The defense has 6 minutes and 21 seconds remaining for direct examination, and the prosecution has 4 minutes and 14 seconds remaining for cross-examination.
Thank you. And for the convenience of the court, my name is Ishel Aguilar-Moore.
For the convenience of the court, my name is Rory Scheinbaum.
May I begin?
Yes.
Could you please state your name, age, and occupation?
My name's Lee Crotty. I'm 35 years old, and I'm the host of the YouTube show, The Right Choice of News, or RCN.
Can you tell us a little bit more about your YouTube show, The Right Choice of News?
RCN is about revealing truths that the mainstream media suppresses. As of March 2019, I had around 1.4 million subscribers.
And what happened to your amount of subscribers in January of 2019?
I just wasn't gaining new followers at the same rate I'd previously been, so my agent Aaron Sullivan recommended I increase my interaction with fans.
Did you take your agent's advice?
Of course. In March of 2019, I began to create several group chats in which I'd promote my content so that my followers would be interested enough to advertise it themselves.
And did you ever create one of these group chats with someone by the name of Remy Mononttoya?
Yeah, but I just knew them as Remy.
And through this group chat, were you able to get close with Remy?
No, I know Remy, but we aren't close. We mainly interact through the group chat, though we have met at a few meet and greets in the past.
And what did you send to the group chat that included Remy Mononttoya on February 12th?
I sent a short clip from a video I was planning to post regarding government secrets. I'd previously discovered an envelope to do with Drew Marshek and the confirmed existence of extraterrestrial beings.
And was sending this kind of content to your group chat something that you regularly did?
Yeah, it wasn't unusual for the group to get the uncensored version of what I'd later be posting.
And what did you post to YouTube on February 13th?
I posted a video regarding government documents with the name and address of the official Drew Marshek blurred out.
Then why didn't you blur out the same information when you sent it to the group chat?
I guess I just forgot to by accident. I was so excited by what I just discovered.
And in the edited version of the YouTube video that you uploaded, what did you tell your viewers?
I told my viewers I was going to march straight to the official's house and take the information that rightfully belongs to us.
Ms. Crotty, what is your intention with this kind of language that you use?
The language used is simply passionate, to demand from Marshek answers about what the government's up to.
I'd like to bring your attention to an exhibit previously marked as Exhibit C. Do you recognize it?
That's Remy and I's WhatsApp conversation.
And does this exhibit accurately reflect the WhatsApp conversation?
Yes, it does.
Let the record reflect that the witness has properly identified Exhibit C. Could you read to me the text you sent to Remy after Remy says, "Anything you need, I'm there. You can count on me"?
I said, "I need you to go to that Agent Marshek's. It's near you. Get the rest of the documents. I won't be in the area tomorrow, otherwise I'd do it myself. Can you go to the house and try to get them before the meetup tomorrow?" But I also told Remy not to do anything I wouldn't do.
So can you tell me what your expectation was of Remy Mononttoya after exchanging these messages?
I only expected Remy would go to the house, knock on the door, and maybe demand the documents. I never thought they'd do anything illegal.
And can you tell us about your interaction at the meet and greet the day after these texts were sent?
I was approached by Remy. Then Remy started rambling so quickly I couldn't make out a single word, and I got really worried about their mental state. That's why I offered for them to come over after the meet and greet.
But why did you invite Mononttoya over to your home, especially since you really didn't know them?
Well, I always try to maintain a strong connection with all my fans, and I'm loyal to them because we're part of this movement together.
And can you tell us what happened on the car ride back to your residence?
On the car ride back to my place, Remy suddenly kicked something at their feet and yelled, "All my problems are because of these files and stupid briefcase."
Objection, Your Honor. Hearsay.
Your Honor, this doesn't go to prove the truth of the matter. It's simply foundational for my next question. This is an already established fact in the case.
Anything further regarding your objection?
No, none, Your Honor, for that limited purpose. That's good. Thank
I'll
you.
accept it for the limited purpose outlined by questioning counsel. So I'll overrule. Answer will stand. Please continue.
Thank you. I'd like to bring your attention to Exhibit A. Do you recognize it?
No, not really. That might be the briefcase that Remy kicked, but I could only glance at it since I had to keep my eyes on the road.
And did you ever hold possession of this briefcase?
No, Remy kept it with them.
And did you know what was inside of this briefcase?
No. The way it flopped around, though, honestly made it seem like it could be fake or a prop or something. So I asked Remy if it was a prop, and they got really worked up by the question.
2 minutes.
And what did Remy ask you when you both arrived at your residence?
Remy asked to lay low for a while because they thought they were being followed.
And did you ask Mononttoya to elaborate on what that meant?
No, I was really worried about how paranoid Remy was acting, so I just took them to my guest house to try and help them calm down.
And did you and Mononttoya speak anymore after you took them to your guest house?
No, we both went to bed.
And can you tell me what you remember after waking up the next morning?
I remember seeing Remy pacing in the yard, and then I remember hearing yelling, so I ran outside. That's when I saw Remy being arrested. I started talking to the officer who arrested Remy.
What did the officer tell you?
The officer told me that Remy had been arrested for burglary and assault.
And can you tell us what happened 6 days later?
I was arrested for aiding and abetting Remy in burglary with accessory after the fact.
Ms. Crotty, did you have any intention to help Remy Mononttoya
1 minute.
to an official's home?
No.
Did you help Remy Mononttoya steal documents from inside an official's home?
No.
And Ms. Crotty, did you have any intention of helping Remy Mononttoya assault an official?
No, I barely know Remy. I was just trying to make a living, be good to my fans, and provide a public service.
Thank you. No further questions at this time, Your Honor.
Cross-examination, please.
Yes, Your Honor. And for the convenience of the court, once again, my name is Nariana Bratholz. May I begin?
Yes.
Thank you, Your Honor. Now, you stated that you created small group chats with some of your most engaged followers, yes?
Yes, I did.
And in those chats, you regularly sent sneak peeks of your new content, yes?
They often had really helpful feedback, so I did.
Is that a yes?
Yes, it is.
Thank you. You chose Remy Mononttoya for one of those group chats, is that correct?
That's correct.
You told the police that Remy had said in a group chat that he shoved someone who called your group a bunch of lunatics, yes?
Yes.
In your statement to the police, you said you admired Remy for standing up for the cause, didn't you?
Yes, I did admire them for not letting people walk all over their beliefs.
Thank you. So you knew that Remy Mononttoya was quite capable of being violent if challenged, yes?
I suppose it happened once.
Now, turning your attention to February 9th, the anonymous envelope that you received contained the full name and address of the report writer, Drew Marshek, yes?
It did.
And on February 12th, you sent a sneak peek of your new video with Drew Marshek's name and home address to Remy Mononttoya's group chat. Is that correct?
Yes, unfortunately, I was just so excited by what I discovered, it slipped my mind to blur it out.
Thank you. So you broadcasted the BOI agent's personal information to your most fervent and fired up followers, yes?
On accident, but I did make sure to remove it in the video I posted online.
Thank you. But when you released the full video on Thursday the 13th, you blurred out the victim's name and home address on the advice of your legal team, yes?
Yes, they advised me to do things that will help my brand.
Thank you. But you knew that Remy already had Mr. Marshek's home address, didn't you?
I knew that I'd accidentally sent it in the group chat, so I suppose Remy would have seen it, yes.
Is that a yes?
Yes.
Thank you. In fact, you ordered Remy to get into Drew Marshek's house and get those documents, yes?
I asked a follower for a favor to go collect the documents, and I did use those words, but it was a request.
So in your own words, you ordered Remy to get into Drew Marshek's house and get those documents, yes or no?
Yes, I asked them that.
Thank you. Now, Miss Crotty, excuse me, it is your testimony that you did not know what Remy had done. Is that correct?
No, I didn't.
You did not know what was happening until Officer Byrd told you when he arrested Remy, yes?
That's correct.
Your claim is that Remy was completely incoherent when they tried to tell you what they had done, yes?
Yes, they were clearly in a state of panic.
So you couldn't understand a thing Remy said to you at the meet and greet event? No?
No, I couldn't.
Or in your car? No?
All I remember is that I kicked the briefcase and yelled that that was the cause of their problem.
Thank you. Is that a no?
That's a no.
So you are saying that Remy was incoherent for hours on end, yes?
Yes.
And yet when Officer Byrd came to your house in the morning to arrest Remy, it was you who brought up the stolen documents, no?
I brought up how Remy stayed in my home.
When Officer Byrd came to your house to arrest Remy, it was you who brought up the documents.
I brought them to the guest house, but I didn't have any knowledge of the documents.
It was you who brought up the documents to Officer Byrd, yes or no? In your own words, sure, I told the kid to get down there and get those documents, yes or no?
Oh, yes, I did say that on the way to the police station after they'd already discovered the documents. I'm sorry, I was just confused on the question.
Thank you. But this is before you had any input from Officer Byrd on what Remy had taken, yes?
Yes.
In truth, Miss Crotty, you knew exactly what Remy had done and what she had taken because you told her to do it, yes?
I didn't know what she'd taken. It's correct, I did tell her to do it, but I wasn't sure exactly what she'd done or
Thank
what
you.
illegal actions.
No further questions, Your Honor.
Any redirect, please?
Yes, Your Honor. Can you tell us what your expectation was of Remy Mononttoya after the WhatsApp conversation?
Objection, Your Honor. Outside the scope of cross-examination.
Response as to that objection, please?
Your Honor, this is not outside of the scope of the cross-examination. Counsel brought up in her cross-examination the messages that are in Exhibit C, and therefore I'm allowed to address them.
Anything further regarding your objection?
Yes, Your Honor, I might have brought up the group chats that were in question, but I never brought up whether or not the defendant, what the defendant intended by saying those. Sorry.
Matter submitted. Thank you very much. Matter submitted. I'll overrule the objection. Please proceed.
Thank you. I'll re-ask the question. Can you tell us what your expectation was of Remy Mononttoya after the WhatsApp conversation?
I expected Remy to go to the official's house, knock on the door, and demand the documents. I didn't expect them to break in.
Thank you, Your Honor. No further questions. May this witness be excused?
Yes.
And the defense would also like to ask Exhibit A and C be admitted into evidence.
Any objection?
None, Your Honor. The prosecution would like to also ask that Exhibit B be entered into evidence.
All right. A and C are in evidence. Any objection as to B?
None, Your Honor. Thank you.
B will be in evidence also.
Thank you, Your Honor.
Anything further on behalf of the defense?
No, Your Honor. The defense rests.
Thank you. All of the evidence has been submitted. We will proceed with closing arguments at this point. The initial closing argument is with the prosecution. Is the prosecution ready?
Yes, Your Honor.
At your convenience.
Thank you. And for the convenience of the court, my name is Nariana Bratholtz. We need those documents, Remy. You need to get into that house tomorrow. These are the defendant's own words, and as we all know, words have power. Today, Your Honor, we have proven beyond a reasonable doubt that the defendant, Lee Crotty, is guilty of aiding and abetting first-degree burglary and accessory after the fact. For Lee Crotty to be guilty of burglary as an aider and abetter, all the prosecution must prove is that Crotty knew of Mononttoya's unlawful purpose and intended to aid or encourage the commission of the burglary. To be clear, Your Honor, there is no legal requirement that specific language be used in order to promote the commission of the crime. Crotty did not need to say the word burglary. In order to prove accessory after the fact, we must prove that the defendant knew that Remy had committed a burglary and, afterward, aided Remy with the intent that she avoid apprehension by the authorities. There is no dispute that on February 12th, Crotty released Agent Marshek's full name and home address to Remy Mononttoya and other group chat members. She specifically points out the identity of the report writer multiple times, as is clearly seen in Exhibit B. We have to make demands, march up to this Marshek person and demand answers. And if Marshek won't answer us, we'll just take what is ours. Demand, not ask for, not request, demand. If Marshek refuses, take what is ours. These are not passive words, Your Honor. They are a call to action. The text messages sent between Crotty and Mononttoya on February 14th reinforced that Crotty intended to dox Marshek because, knowing full well that Remy Mononttoya had the victim's name and home address, she tells Remy, "I need you to get to that Agent Marshek's place. It's near you. Get the rest of the documents. I won't be in the area, otherwise I'd do it myself." Now, Lee's intent cannot be in question because we know that she told Remy to go to Marshek's house, stressing the importance of Remy's mission. Get the rest of the documents. And Lee Crotty very specifically told Remy Mononttoya to get into that house. Lee had already primed Remy to commit the burglary by providing the victim's home address and making it crystal clear that if Drew Marshek refused to turn over the rest of the documents, the appropriate course of action was to, in his own words, take them. The defense may argue that Crotty believed that Marshek might just hand over the rest of the documents when prompted, but then why tell Remy, you need to get into that house tomorrow? Not, you need to go to Marshek's house and talk to him, or you need to ask Marshek for the rest of the documents. No, you need to get into that house. The instructions to Remy are clear. These are the defendant's own words. The defense has tried to play down the relationship between Crotty and Remy, saying that they weren't close, that Remy was just one of her many fans, and that she almost didn't recognize Remy at the meet and greet event. However, I ask that you recall the testimony of Aaron Sullivan, Lee's own agent, who testified that Lee called Remy my friend. Sullivan also testified that it looked to her that Lee knew Remy quite well, and that their interactions with Mononttoya were not the same as they were with other fans. The defendant even embraced Remy. The question remains, why? Why ask Remy to get into Drew Marshek's house? Why not do it herself, or ask Zuri O'Neal, Buzz, or any other member of the small group chat? Why? Because the defendant knew Remy, knew that Remy was capable of using force to support the movement. The defendant even admitted to admiring Remy for this. Crotty was not going to do it herself. She needed to distance herself from the crime. She needed plausible deniability. The defendant and opposing counsel may try and say that Crotty did not know what Remy had done. The defendant testified that she could not understand what Remy was saying when she tried to speak to her at the meet and greet event, claimed that Remy was speaking too fast, rambling and incoherent, totally deranged. And afterwards, in the ride back to Lee's own house, Remy was still rambling. Lee still couldn't understand what Remy was saying. But by the time they got to the defendant's house, Remy seemed coherent enough to tell Lee that she needed a place to lie low in case she was being followed. Lee testified that even then, she did not ask Remy to elaborate. How convenient. So, how do we know that Lee Crotty knew what Remy Mononttoya had done? Well, Officer Max Bird testified that when escorting Lee Crotty back to the station for further questioning as a potential witness, Lee said, "Sure, I told the kid to go down there and get those documents, but I'm not responsible for Remy doing anything illegal." And so you have to ask, if Lee had no idea Remy had committed a crime as she claims, how would she have known about the stolen documents? Officer Bird didn't tell her. That was very clear. Lee knew about the stolen documents because Remy Mononttoya told her the day before. Remy Mononttoya getting caught was not a part of the plan, and when she was caught, the defendant knowingly took her home and harbored her, hid her in her home, even though Remy had clearly stated that she needed to lie low. A non-guilty party does not need to lie low, Your Honor. Lee Crotty told Remy Mononttoya where to go, when to go, why to go, and how to do it. Crotty had motive, intent, and knowledge. She knew what she was doing. She told Remy Mononttoya exactly what she wanted her to do. After considering all of the evidence, the people ask that you find Lee Crotty guilty as charged. Thank you.
Thank you very much. Defense closing argument, please.
Yes, Your Honor. And for the convenience of the court, my name is Ishelle Aguilar-Moore. May I begin?
Yes.
Lee Crotty, a passionate woman just trying to provide a public service and be loyal to their fans, is being wrongfully accused at the stand today. Your Honor, my client Lee Crotty is being charged with aiding and abetting burglary and accessory after the fact. According to the jury instructions, the court must be convinced that there is only one reasonable conclusion from circumstantial evidence, and that is that the defendant was guilty. But if there's more than one reasonable conclusion and at least one points to evidence, you must find Lee Crotty not guilty. I will be breaking down each of the charges today to show you why there's insufficient evidence to charge Lee Crotty with any crime. Starting with CalCrim 401, aiding and abetting, and CalCrim 1702, aiding and abetting when it comes to burglary. The defendant may be guilty of this crime in two ways. The first is that they directly committed the crime, and that responsibility lies on Remy Mononttoya, not my client. And the second is that they may have aided and abetted a perpetrator who directly committed a crime, which is what the prosecution is trying to prove. But the prosecution falls short in attempting to prove the next three requirements. The first is that the defendant knew the perpetrator intended to commit a crime. There is reasonable doubt that Crotty intended for Mononttoya to commit any crime. Crotty said that they simply wanted Mononttoya to knock on the door and maybe demand the documents. There's enough reasonable doubt that shows that Crotty did not believe Mononttoya needed to commit a crime to retrieve these documents. The second is before or during the commission of the crime, the defendant intended to aid and abet the perpetrator in committing the crime. During the crime, Lee still has no knowledge of what's occurring. In fact, they were focused on their own meet and greet with no communication whatsoever with Remy Mononttoya during the crime. Then Remy becomes frantic, never even explaining to Lee what had just happened. Mononttoya even says in the cross that she doesn't even remember everything she said to Lee. How can a witness be trusted that was in such a panicked state that they can't even recall their own testimony? In fact, Ms. Mononttoya admits that the only reason she thought Lee understood what had just transpired was because Lee looked genuinely concerned, showing that there is reasonable doubt that Crotty knew of the crime that she supposedly aided and abetted to. The third is that the defendant's word or conduct aided, facilitated, promoted, encouraged, or instigated the perpetrator. Yes, Lee Crotty does use encouraging language, but that is Crotty's job and passion. It's not illegal to use strong language, especially when your job is solely based on inspiring others. Crotty is a 21st century female entrepreneur with many political aspirations, so using strong language is necessary for her to create the change she wants to in the world. Crotty also never explicitly tells Mononttoya to break into Marshek's home and steal anything, and a person cannot be charged for a fan's misinterpretation of their words. You also hear from Zuri O'Neal, a participant in these venting sessions, say that the only reason this sort of language was used was because they're all so passionate about their cause and that this language was harmless. These group chats also included 5 other people. Why was it that only Remy Mononttoya became violent and out of control? That's because Remy had motives and passions of their own, and it is not Lee's fault that Remy chose to take action because of their own passion. You also hear from Dr. Jess Bayart that Remy acted independently of Lee's influence, separating Remy's adoration of Lee from the reality of their actions, which is typical of Gen Z fans who often act independently from their idol, and their actions aren't prompted by the person they idolize. Remy really did idolize Miss Crotty. They were a follower of them for a long time, and they admired Lee. But Mononttoya's intense adoration of Crotty and harmful attempt to please them is not Lee's fault. Moving on to Calcrim 440, accessory after the fact. The people must prove that the defendant knew the perpetrator committed a felony. Even in the car ride back as Remy carries Drew Marshek's stolen briefcase, Lee asks Remy if the briefcase was a prop. What would be the need for Lee to pretend that they didn't know what was inside the briefcase if no one else was in the car, let alone if they were in some sort of crime partnership? And after the felony had been committed, the defendant must either harbor, conceal, or aid the perpetrator. The prosecution tried to tell you that Miss Crotty inviting Mononttoya into their home may be an attempt to harbor or conceal Mononttoya, but a more reasonable explanation is one you hear from Crotty themselves, that they invited Mononttoya to their home because Mononttoya was very obviously in a bad mental state. You also hear from Aaron Sullivan that Lee always looks out for their fans, and being concerned for their fans is typical of Lee, who cares for their supporter and their well-being. In fact, Crotty and Mononttoya never even discuss the crime. Mononttoya instead tells Crotty they think they're being followed, not that they committed a crime, giving Crotty even more reason to want to help protect Mononttoya. The third is that when the defendant acted, he or she intended the perpetrator avoid or escape trial, conviction, or punishment. Miss Crotty takes Mononttoya to stay in their guest house, not some secluded or hidden room. If Miss Crotty was trying to hide Mononttoya from the authorities, they sure didn't try very hard. Your Honor, the people have yet to prove beyond a reasonable doubt that Lee Crotty aided and abetted a crime, nor that they acted as an accessory. Please do not send an innocent woman to jail for caring about her fans and being passionate about her beliefs. At the end of this trial, the defense asks you to find Lee Crotty not guilty on all charges. Thank you, Your Honor.
Thank you very much. Any rebuttal on behalf of the prosecution?
Yes, Your Honor. May I begin?
Yes.
Thank you. Now, the defense has argued that there is no way that Crotty believed that Remy had committed a crime, and that Crotty never explicitly told Remy to get into that house. Once again, Your Honor, I ask that you turn to the law. There is no legal requirement that specific language be used to promote the commission of the crime. Whether or not Crotty said to burglarize Drew Marshek's house is not in question. Furthermore, Officer Bird testified that when escorting Crotty back to the station for further questioning, Lee said, "Sure, I told the kid to get down there and get those documents." The defendant's own words count against him.
30 seconds.
Thank you, sorry. The defendant's own words count against him in this case, Your Honor. We must look to the words. Take what is ours. Demand answers. Get into that house. Your Honor, Remy Mononttoya did not act alone. Lee Crotty told her exactly where to go, when to go, why to go, and how to do it. After all things considered, Your Honor, the people ask that you still find Lee Crotty guilty as charged. Thank you.
Thank you very much. Rebuttal argument by the defense.
Yes, Your Honor. The prosecution's argument regarding Crotty's specific words still has reasonable doubt. I've proven that Remy Mononttoya did this out of her own accord. She was one of 5 other members in a group chat who also received the same encouraging language from Lee Crotty, yet she was the only one who committed a crime. And that's because Remy Mononttoya had passions of her own, which were not caused by Lee Crotty. Again, Your Honor, at the end of this trial, I ask that you find Lee Crotty not guilty on all charges. Thank you.
Thank you very much. I appreciate the arguments of both counsel. Before I rule and provide a verdict, students may confer with their attorney or teacher coaches regarding any trial irregularities. If you could please do that now, and I'll give you a few seconds for that.
None from the prosecution, Your Honor. Thank you.
Thank you.
None from the defense either, Your Honor. Thank you.
Thank you very much. As you folks know, my decision on the pretrial motion and my verdict has no impact upon the scoring in this. I felt both attorneys did an excellent job in the pretrial motion, but I wanted to hear all the evidence as part of the final, so that's why I found in that way. I will appropriately alienate all sides by finding the defendant not guilty as to count 1 and guilty as to count 2. So at this point, I realize we're doing this in a somewhat artificial environment, but I'm going to applaud for everyone involved in this matter. I really enjoyed working with all of you folks this evening. I can see why you 2 teams are in the finals. Again, all the parents, family, friends should be extremely proud of everyone who was involved in this presentation this evening. I thank the teacher coaches for their involvement. I thank the attorney coaches for their assistance. Those are hard jobs, and folks spend a lot of hours preparing for an evening like this. It was my pleasure to watch all of you work. As I mentioned at the beginning, we have 5 excellent attorneys, highly experienced trial attorneys from the County of Santa Cruz who were kind enough to donate their time. I will ask counsel if they have any particular comments to provide them at this point. And let me first ask of Diana Sapia if she has anything that she'd like to offer to the participants.
Yes, thank you, Your Honor. I have a couple of notes here that I'm really excited to call out. I want to say that at the very beginning, Chance did a fantastic rebuttal to the court's questions about not using violence and yelling, and just that was a fantastic rebuttal on the pretrial. And Molly's perfect pacing and choice of simple words and smiling when she's talking about her witnesses on her opening statement. It was just, my goodness, that was just the perfect ability to follow what she was saying was fantastic. And then I wrote that, and I apologize for having first names. I didn't have enough time to write everybody's names and their characters, but I've got Amira, Ayana, and Amara. I wrote best, the 3 of you on direct and cross for that particular witness was just fantastic. But I must say it got followed up by another best. The next group, Nayana, Ishel, and Elisa did a fantastic job too of just interacting with each other and following back and forth with your questions. It was just fantastic. I want to do a call out for the judge because the judge did such a great job. And the witnesses, Karina and Rory, I thought you guys were really credible, believable. You pushed back on your cross. And the last thing I wanted to say was I thought Narayana hit it out of the park on her closing statement. So everybody did a fantastic job, but I really wanted to call out those few comments. Thank you.
Thank you very much. I'll move to Pamela Mattison, another, like with Ms. Sapia, excellent trial attorney, very experienced. Ms. Mattison, any comments that you have at this point?
Thank you, Your Honor. I would just echo what Dinah said. She took all my notes and already talked about them. What I will add is that as has been happening throughout these mock trials, I think all of the witnesses got better on cross-examination. So congratulations to all of you. I want to call out Ms. Christian, who was one of the most excellent expert witnesses I've seen during these mock trials, very natural and persuasive, and you held your ground on cross-examination. And I do want to, I'll just chime in and say congratulations on the closing argument to Narayana. I agree, she knocked it out of the park. So great job all around. It's excellent watching both of these teams, and I appreciate the efforts that you've all put into these months and months. So thank you, and I'll pass it on to the next.
Thank you very much. The next attorney I'll call upon is Aaron Mohammed. Again, highly experienced, excellent attorney. He appeared in front of me this morning, so I have a lot of respect for Mr. Mohammed. And sir, any comments that you have for the students?
I do briefly. A great job on all accounts. I did mock trial in high school in this county. I won't say which school I was in. I went to the state competition a couple of times. I'm assuming one of you is going to go on. So my comments are directed at those things. At this level, at the finals, and certainly if you get to state, everyone is going to be super polished. So you've got to find a way to get those extra points when you know that your opponents are going to be very polished. And to that end, I want to point out a couple of comments. In the pre-trial, at the beginning, I think there was a little bit of confusion on the part of one of the attorneys about what was answered, but you said, I'm sorry, Your Honor, could you rephrase? Could you repeat that question? I didn't understand. And you carried right on. That's perfect. That happens in actual argument at trial and in cases all the time. On the other side, there was a question about, don't you think that being in the back of the police car is implicitly kind of an intimidating situation? The answer is yes. And if you're going to argue against that, the answer is absolutely not, Your Honor. A trusted police officer, go emphatic with it. That'll appeal to people, and also don't say handcuffs. If you're trying to say that the police are not intimidating, don't say handcuffs. And on a previous example, on the objection about unfair extrapolation, same thing. I think it was a fair extrapolation and it was a very incisive point. So make it, go into the argument, say, hey, if the agent knew that this person had done this, it would be in the brief. If it's not in there, it's a fair extrapolation that she didn't say it. So go in, get those extra emphasis and extra points. And finally, on the closing, I did think that both attorneys did a great job on the defense. Focusing in on the elements that needed to be charged was key. You always need to do that. Show what you need to show or what they need to show. Go through the Cal Jur or the statute or whatever it is, and make sure to add that to your closing. Great job. Good luck to whoever wins. It was really close, and I don't even know who I had on top. So thanks so much. Great job.
Mr. Mohammed, thank you very much. I'll move on to Michael Tunick. I've known Mr. Tunick for many years, an excellent attorney, handles a wide range of issues in Santa Cruz County. And sir, any comments that you have for these students, please?
Yes, thank you, Your Honor. Both teams, congratulations on reaching the finals and both performing well. I'm proud of you, and you should be proud of yourselves. I'm sure that your parents, your peers, and your coaches are indeed. And whoever makes it to state, I wish you the best. I'll start my comments on Team Q. Pretrial attorney Chance Hosler, I thought you did a great job on pretrial, particularly related to your argument about how it was not a custodial setting and your distinguishing of People versus Boyer. And what cracked me up about your performances when you said to Judge Volkman, I completely spaced out. My bad. Next time I'm in Department 5 in front of the Honorable Timothy Volkman, I'm going to say I spaced out. My bad, and see what kind of reaction I get. Lillette Edwards, you had a very good presence about you, and you spoke with clarity. I thought you did a really good recitation of the elements of the crime during your opening statement, and I thought you did a good job on responding to objections from the other side. Mira Narayan, I thought you had a good cross-examination of Dr. Bayart, and it was very well drafted. Nariana Bretholtz, you have a really good delivery in everything, your closing argument, your direct, your cross. You got your lack of foundation objection sustained during your questioning of Remy Mononttoya. Good job there. You had a very good cross-examination of Lee Crotty, and I got the sense that you had that particular cross-examination down with no need to look at your notes at all, and a very nice closing, as others have said. Richard Anberg Katzen, you did a nice articulate job of presenting witness Drew Marshek, and you did a nice job on that testimony, and you clearly had a solid knowledge of the facts. Ishelle Aguilar Moore, all your performances were solid. I thought you had a very good response on the hearsay objection that was made to you on your direct of Lee Crotty, and that showed good thinking, good participation on your part, and you really came on strong in your closing. Well done. Molly Endert Tatum, nice opening. Good job previewing the witness's testimony and what they were going to say. And your cross-examination of Drew Marshek was also good. You did a nice job of framing your cross-examination questions to elicit yes and no answers. Ayanna Bush, your direct exam of Aaron Sullivan was very well drafted, and also your direct of Jess Bayart was as too, and nice cross of Kai Chavez. You got as much from that witness as you could possibly get. I thought you did a good job. And Rory Scheinbaum, that of the 3 trials that I have scored, that was the best performance of Lee Crotty that I had seen in all those 3 trials. And Ella Henderson, in your testimony of Zuri O'Neal, I thought you had a good grasp of the facts. Thank you, everybody. Well done.
Thank you very much for those comments. Our final scoring attorney is Creighton Mendeville. He's a leader in the Santa Cruz legal community, and I thank him for his volunteerism this evening. Sir, what would you like to offer for the students?
Briefly, so we can get on to the award ceremony, I wanted to just congratulate both of the closing attorneys, and I'm sorry if I slaughter names. With a name like Creighton Mendeville, I get mine torn apart often. But Nariana, I thought you were poised and smooth presentation with a really strong command of the facts. And Ishelle Aguilar Moore was an excellent summation with a great creation of a storied description of the defendant. I thought that was a really good topping on top of the cake. And I thought both groups did well. And I look forward to seeing you in court in years in the future.
Thank you very much for those comments. I'll echo everything. I thought everyone was outstanding. You folks were poised. You were well organized. It was a pleasure for me to watch all of you. I will just specifically, because the judge is more deeply involved in this aspect of the case, I'll specifically congratulate the 2 attorneys involved in pretrial attorney Hosler, and I hope I get the last name correct, pretrial attorney Manalidi. It is not easy being the pretrial attorney in these competitions. You don't know what the judge is going to ask. You don't know when the judge is going to interrupt you. You don't know what the judge is going to be interested in. You then have to get back on your point after answering a question that perhaps is not particularly clear or well phrased. I thought both of you, well organized, very confident, very poised, were able to get back on point, very efficient arguments. So it was a pleasure watching each of you work. I, again, congratulate both teams for how well you did. It was my honor to work with all of you, and I'll applaud, and I hope others are applauding along with me. It's my understanding that we are reconvening at 7:30. So I believe we're going to be, for lack of a better phrase, off the record for about 13 minutes, come back at 7:30 for the decisions from the scoring attorneys and various awards. So I'll see you folks at that point. Thank you.
Thank you.
Good evening, everybody. Welcome to the 2020-2021 Mock Trial Awards Ceremony. My name is Faris Sabah, and I'm the Santa Cruz County Superintendent of Schools. I'm joined by Dr. Michael Painter, Director of Student Services, and Judge Volkman. Thank you for joining us tonight to celebrate the outstanding students of the mock trial program. I want to give a big congratulations to all the teams that participated. We know that this has been a really tough year. Not only has it been tough to adjust to distance learning, but you've had to adapt to a virtual mock trial competition as well. The County Office of Education has a long tradition of supporting mock trial in our county. Tonight, we're proud to hear and honor the students with the most nominations in individual categories. I have a little bit of feedback. Hold on one second. All right, let's see if that takes care of that problem. Tonight, we're proud to hear from and honor students with the most nominations in individual categories, as well as announce some team awards. We'll also be hearing more from our mock trial students and celebrating the many folks who participated and supported the mock trial program. And of course, we'll be announcing the winner of the mock trial finals competition, which just ended a few moments ago. I'd like to take a moment to thank our partners, the Constitutional Rights Foundation, Santa Cruz Superior Court, and the Santa Cruz Trial Association. This year, we had 8 judges, 3 pro tems, and more than 30 attorney volunteering their time in support of mock trial. The Santa Cruz Trial Association has a few congratulatory awards they'd like to share with you. We'd like to play a video for you right now. And I think I'm going to need to...
Hello, my name's Sam Forbes Roberts. I'm the co-president with Dinah Sapia of the Santa Cruz Trial Lawyers Association, and I'm here with other members of the Santa Cruz Trial Lawyers Association, and we wanted to congratulate you all on all the hard work you've done and everything that you've achieved in getting to this point. And in fact, all of the people that have participated in this Trial Lawyers Association and COE competition, mock trial competition this year have shown a perseverance to get through a lot of very difficult times with the remote appearances, technical difficulties, changing up everything that you've had to do in the past. The attorney coaches have worked so hard. The teachers have worked so hard, and so we're here just to really commend you on that great work. The Santa Cruz County Trial Lawyers Association has been involved for quite a number of years in helping out with the mock trial event and competition. You know, some of our past members have been presiding judges. This year, one of the members on this panel here today, Heidi Simonson, has been a presiding judge. We've all been involved with scoring. We are just very impressed, and we are very proud of our community and the young people that are doing this work. I'm going to pass it on now to one of our members, Heather Rogers, and she is going to talk to you and give you a little more feedback on what she's seen and motivate you guys to charge forward and keep up with the good work, the hard work that you've done. Your community needs you. Your country needs you. Law is a great equalizer. It's a great opportunity to protect society and also to champion and give power to those who are oppressed and held down by inequality. And I just encourage you all to keep up the hard work. Heather?
Thanks, Sam. Fight for the things that you care about, but do it in a way that will lead others to join you. This advice comes from a courtroom hero, the late U.S. Supreme Court Justice Ruth Bader Ginsburg. Over the last few weeks, you've shown us how to do that. It's scary to show up, to stand up, to speak up for something, but you did it. Justice Ginsburg is one of only 4 female Supreme Court justices in U.S. history. She fought tirelessly for the rights of women, the LGBTQ community, undocumented people, and the accused. She wasn't afraid to show up, stand up, and speak up. just like you. Outside this courtroom, there's a world full of worthy causes looking for champions, and I challenge you to become a courtroom hero. Take what you learned here, find the things that you care about, and fight for those things in a way that will lead others to join you. Congratulations. We can't wait to see what you do next.
Lisa?
Hi, I'm Lisa Peck. I was one of the attorney scorers this season and was fully honored and excited to be presented with such an amazing group of young folks who really put their all for it and tried everything they could to learn the system, show up, as Heather says, be not afraid. And I was just super impressed with everything. I'm a civil rights lawyer. I know what it takes to fight the good fight, fight the difficult fight, sometimes get knocked down, sometimes be able to stand up hard, but in every case, try to seek justice for the people who need you most. In order to do that, I have 3 things I want to share with you that I have found in my career and in my life that have helped most. 1, be yourself, be genuine. Authenticity is far and away the best tool of persuasion you can ever find. Know your stuff, do your studying. It helps you be confident. You're always going to be nervous at the outset of whatever it is you undertake, but as my dad, who used to be a professional ball player, said, if you're not nervous before the game starts, that's when you should start to worry. So nervousness is okay. It helps you jump into the fray. And once you get going, you'll start to settle in. If you know your stuff, it'll bespoke confidence, not only in yourself, but in the people who are watching you and your audience, whatever path that may take you. And last is be willing to go out on a limb. It's okay to be afraid. It's okay to be nervous. So what I always say to myself and I tell my team, you know, what's the worst they can do? They could say no. But the upside can be out of this world for both you and your client. So don't be afraid. Go out on that limb, even if it's real skinny and narrow and scary. The farther you leap, the further you'll go. Good luck. Can't wait to see it all.
My name is Pamela Mathieson, and I've been a scorer for many years. And I want to thank all of the students and the teachers and the coaches and everyone around this program that supports it. I appreciate the months and months of hard work each of you have put into the preparation for this mock trial season. Over the years that I've scored mock trial, I've watched many young students like you develop into great young adults. You've developed a good understanding of our judicial system. You've gained practical skills, great analytical abilities. You've learned teamwork and communication skills. And it's exciting to me to watch you grow in your self-confidence, and as that builds and how you become a more fully developed young adult year after year. So I know that you will take the skills and the knowledge that you've developed through this program with you on your journey forward. And hopefully some of you will journey back into the legal field. But wherever you go, I think you're long going to remember the mock trial program for helping you acquire the skills and the confidence that will serve you for a lifetime. So unless you are a graduating senior this year, I hope to see you back here again next year. And congratulations to the winner, the winning team and the runner-up team. It's been an excellent year. Congratulations. Thank you.
Hi, my name is Heidi Simonson, and tonight I'll be portraying the role of family law litigator. I've been a presider this year to my great honor, and before that I was a coach, an attorney coach for about 6 years. And I believe that the Constitutional Rights Foundation is a very cool organization. Over the years, they've presented us with trials that have very timely, thought-provoking issues. Now, I know that almost all of you are volunteers. You receive no school credit. Obviously, the coaches receive no pay. So for each one of you, your commitment is completely self-motivated. Your teachers and coaches are honored by getting to know each one of you students better and your families. And I want to tell you that your final scores are only one metric of how hard you've worked and what obstacles you've overcome to do this. And you may or may not be interested in the law, but the confidence, the cleverness, the energy that you put into your mock trial clubs has and will serve you well in the years to come. Now, I want to leave you with the immortal words of Lee Crotty. That kid took things way too far. Thank you.
We are so grateful to the Santa Cruz Trial Association and grateful for their kind message. We'd also like to share a message from Carlos Barba, a graduate from Watsonville High School. He's also currently an assistant district attorney, and he is one of the attorney coaches for PV High School. And he sends this congratulatory note. I'd like to congratulate all of you throughout this competition. You've shown hard work, teamwork, dedication, and resiliency. This experience and the skills you learned will help you for the rest of your life. While a student at Watsonville High School, I participated in a similar court-related program and served in various court roles. That program helped me learn about the criminal justice system and planted a seed that I too could be working in a courtroom as an attorney one day. It also helped jumpstart the skills to be an advocate for myself, others, and issues I was passionate about. I hope that it will do the same for you, and I wish you all the best success in your future endeavors. This was from Carlos Barba, who currently is an assistant district attorney. We'd also like to thank all the teachers, the attorney coaches. This year we had 7 teams competing. We know there were countless hours of preparation for these teams. For teachers adjusting to distance learning, adding a virtual mock trial competition was truly a labor of love. This year, there were 2 new teachers, 4 new attorney coaches who stepped up to make sure that their teams were able to compete and had the coaching they needed. So thank you to the teachers and attorney coaches. And now we'd like to hear from our mock trial competitors and why they participated and enjoy and why they enjoy being part of the mock trial program. And so when we asked them, what is it, why you participated, they told us it was to have fun with their friends, to participate, or to practice public speaking, to challenge themselves academically, to meet new people, to learn about the judicial system, to have fun acting, because they want to be lawyers and because they want to get into law enforcement and because they love their community. They've also said that they were learning about the case and the law is fascinating, that they find that community awesome, critical thinking, especially when you're put on the spot, how well their team worked together, feeling accomplished when they do well in the trials, debating like the end of the world is at hand, the bonds created in their team, preparations for a career in law, and the rush of presenting before an audience, as well as being challenged by the judge or opposing counsel. Now, we'd like to hear a few words from one of our mock trial teams.
Hello everyone, we're the student representatives for Team S, also known as Aptos High School, and we would first like to acknowledge the strange circumstances of competing this year over Zoom and during the COVID-19 pandemic. And this threw new challenges to everyone and all of the teams that competed, and we would like to thank everyone for participating and say that we all did a really good job. And I would like to personally thank our team for working hard together to compete this year despite these challenges and despite these circumstances we faced.
We know that our team in particular had a multitude of challenges because of the global pandemic that occurred. We were unable to recruit the same members we had last year. We were unable to recruit our previous coach, previous attorneys, and it was very difficult to get us started. But once we did, we were able to overcome any of the challenges that we had previously had. And looking back at it all, we were able to, everybody involved was able to surmount such
such a particular problem. And I just wanted to say that it's amazing how far that we've all come. And I'm really proud of all of us.
On behalf of our entire team, I'd like to extend our sincerest gratitude to all of the teacher coaches, attorney coaches, scoring attorneys, and judges who volunteered their time to make mock trial happen this year, and to all of the student participants. I know we had less schools participate this year, but everyone who was there at the competitions did a fantastic job. And I'm really proud that through all of the challenges that all of the schools have faced this year, that we were all able to compete and to make mock trial actually happen this year. And hopefully we'll be back in person next year and able to do this again.
We are so grateful to the Aptos High team for their positive message. And I think that their message really resonates with a lot of folks who are listening in tonight and participated in this wonderful competition. And now it's time to give out the individual awards. Every night into the competition, we heard from judges and scoring attorneys how very impressed they were with the students' skill and expertise. Now we're gonna honor some of the students who received the most nominations from scoring attorneys for individual roles. And although we can only honor one student per category, please know that we want everyone to know how proud we are of all of you. Please note that students who are receiving awards have been invited to be on the Zoom and to turn on their mic and camera to say something after receiving their award, since I think that note is not for me. All right. And so starting with, for the role of prosecution pretrial attorney, the award goes to Angela Rocky from Team T. Angela exhibited excellent use of the case law and application of the facts, great flow and confidence in response to judges' questions, and continuing on with grace. Extraordinary preparation and excellent presentation. Congratulations to Angela Rocky from Team T. And now I'd like to invite somebody who has been so essential to this whole competition, Judge Volkman, who's going to be helping me present some of the awards tonight. Judge Volkman?
I'm happy to work with the superintendent in that regard. For the role of prosecution trial attorney, the award goes to Antonia Torres from Team T. Antonio gave an excellent direct and cross-examination, excellent pace, good grasp of the facts, wonderful presentation. So congratulations to Antonia Torres.
All right, looks like we got, there we go. All right. For the role of Remy Mononttoya, prosecution witness, the award goes to Maisie Higgins from Team R. Maisie was unbelievable, answered on her feet, kept a level reaction, and was a credible witness. Great job, Maisie.
Thank you.
For the role of Drew Marshek, a prosecution witness, the award goes to Kiana Cabrera from Team T. Kiana was believable, stayed in character, had a good pace, and used her time well. Exceptional job.
And it looks like I have skipped over some of our students who wanted to say a few words. I totally apologize for that. And so I'm going to back up a little bit because I want to make sure that we give everybody a chance. So Angie would like to say a few words from Team T. Angie, would you join us, please?
Hi, everybody. I would just like to thank the attorney judges for the attorney judges for selecting me for this award, as well as Mr. Jones, our teacher coach, and the attorney coaches from my team for just helping us out through this time, and as well as all my team members and all the people from all the other teams for doing so well during such a difficult situation.
Thank you so much, Angie. And I did also want to ask Maisie if you, I understand that you'd like to speak as well.
I just wanted to say thank you to everyone and all the people on my team.
Thank you so much, Macy. And I think we also have one more award coming up, and this is for the role of Max Bird, a prosecution witness. The award goes to Bridget Baskerville from Team U. Bridget was an engaging and convincing witness. She knew the material well. Great job. Bridget, would you like to say a few words?
Yeah, I just wanted to thank everyone who volunteered their time. It meant a lot to the students and really helped us out. So yeah, thank you.
Let's continue with the award for the prosecution witness in the role of Kai Chavez. The award goes to Mariana Franca from Team S. Mariana knew not just her witness statement, but how it fit into the case. Excellent demeanor and responses, convincing and credible presentation. Mariana was very natural and not scripted. Her answers on cross-exam were great in that Mariana conceded where she had to, but explained why. She sounded like a real trial expert. Ms. Franca, are you with us?
Yes, I am.
Congratulations. Go ahead.
Thank you. I just like to say thank you to everybody who took their time these past couple of weeks. Thank you to my team. And yeah, this is my first year doing mock trial, and it's a lot of fun. Thank you.
Thank you so much, Mariana. And for the role of the clerk, the award goes to Karen Wusheng from Team U. In the words of the scoring attorney, outstanding job. Karen was always very on top of things. This is especially not easy with a virtual environment. Really exceptional work. Karen, would you like to say a few words?
Yeah, thank you to everyone who participated and to all the attorneys, scoring attorneys, the judges for volunteering their time.
Thank you so much, Karen.
Continuing, for the role of defense pretrial attorney, the award goes to Lucy Norris. And again, the superintendent and I are reading quotes, I presume, from scoring attorneys. The quote regarding Ms. Norris, outstanding. Lucy showed the ability to respond to difficult questions with precise answers. Great job. Is Ms. Norris with us?
Yes, hello.
Hello, congratulations. Go ahead.
Thank you. I wasn't really going to say anything, but I guess thanks, guys. Yeah.
Congratulations, Lucy. For the role of defense trial attorney, the award goes to Ayana Bush of Team R. Ayana Bush's cross-examination of Dr. Kai of the prosecution was outstanding. It was a joy to watch. Responsive to statements made, informed appropriate and excellently framed questions in response. Excellent pace, great use of facts, compelling. Great examination and use of material. Very masterful, cerebral, and exacting. And Ayana, would you like to say a few words?
I just would want to thank my team and the scoring attorneys and teachers because I've just felt really supported by them for the past 3 years, and just thank you to everyone.
Thank you, Ayana.
All right, for the defense witness in the role of Lee Crotty, the award goes to Brandon Greenleaf from Team Q. Brandon was very convincing as an actor, as well as pronounced everything well. He came off as very likable and sincere, and not someone I would want to find guilty. Great understanding of the witness statement. Brandon's answers were thorough and persuasive. He was natural and not scripted. Very convincing performance. Nice work on responding to cross-examination. Excellent presentation. Is Brandon Greenleaf with us?
Yeah, thank you to everyone, especially the judges, for volunteering their time. And I had a great time. I hope I'm never a defendant in real life, but I had a lot of fun with this.
Thank you, Brandon.
Congratulations.
For the role of Zuri O'Neal, a defense witness, the award goes to Kevin Sarate from Team U. Kevin did an exceptional job. He reflected the witness perfectly. Great job in responding to questions. Kevin, would you like to say a few words?
Yeah, I would just like to say thank you for, giving me the opportunity to do mock trial this year. And I'd like to, dedicate this award to Mr. Klein, my teacher and coach. Yeah.
Thank you, Kevin.
For the role of Jess Bayart, a witness for the defense, the award goes to Dulce Nambo from Team V. Dulce was believable and easy to follow. Great job. Is that individual with us today?
Dulce is not here with us today, Judge.
All right, thank you very much. But congratulations to Dulce. And please continue, sir.
From the role of Aaron Sullivan, a witness for the defense, the award goes to Natalie Dion of Team P. Natalie performed with grace under pressure. I believe Natalie, a promoter. Excellent job. Natalie, would you like to say a few words?
Yeah, I just want to say thank you to everyone.
Thanks so much, Natalie.
Moving forward to the role of bailiff. The award goes to Ian Nieves from Team V. Ian was knowledgeable about procedure and his role. He was very professional and had an excellent demeanor and tone. Congratulations, Ian. Mr. Nieves, are you with us tonight?
Yes.
Go ahead, sir. Congratulations.
Thank you for this award. And I just really wanted to take a quick second or two to appreciate all of our scoring attorneys, our judges, our teachers, and our coaches for having made this year's mock trial competition possible at all. I understand how difficult it is to continue a program virtually, and I greatly appreciate all the time and effort everyone has put in order to have this competition to come to fruition. So thank you.
Thank you so much, Ian. And now we'd like to announce two team awards. For these awards, it is the teams themselves that nominate other teams and not the scoring attorneys. The winner of the Team Sportsmanship Award is Team T. And this was commented from, this was what the nominating school said. We competed against them back to back, and in both rounds, they managed to walk the fine line between being competitive and being kind. I think that's really the definition of sportsmanship. They were fierce competitors, but they were fun to be in trial with. They didn't let any technical difficulties get in the way of how they presented their case. They showed, they brought so much energy and preparation into both rounds, and they reworked some things for the first time. We went against them, and that really put my students on their heels. Congratulations, Team T.
Moving forward to the winner of the Team Spirit Award. The winner of the Team Spirit Award is Team V. And this is from the nominating school. It took so much spirit and tenacity to keep that team up and running for a second year and establish the program at PVHS. A graduated student came back to organize and act as an assistant coach to the teacher who does not work on the PV campus and only occasionally subs, doing that work because she sees that same spirit and tenacity among the students. The individual growth that we saw with each team member over the course of the season and the competition, and the growth of the team as they work to establish themselves is remarkable, impressive, and it brings a great amount of pride to the city of Watsonville to have the entire city represented in this program. So congratulations to Team V.
Judge, you want to share what the students were asked and what they learned?
The mock trial students were asked what they've learned by participating in mock trial, and the input or the responses that we received are as follows: to be a better public speaker, improviser, leader, and learner. That practice makes perfect, and it's always good to be confident. Teamwork and patience. How to speak up about the criminal justice system, penal codes, and my legal rights. How to speak even under scrutiny. To try and stress less. Practice, 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 and you're always going to be nervous, so don't sweat it too much. That's a good piece of advice for all of us, including judges. How to effectively work with and lead a team, to prepare effectively, to memorize and speak passionately, and to think on my toes. And mock trial has taught me not to underestimate myself. If I put in the work and build up my confidence, I am capable of great things. And I'll turn the balance over to our superintendent. Thank you, sir.
Thank you so much, Judge. Thank you for all your support of this event. It is now time for us to announce the runner-up and first place winners of the mock trial competition. The winning team is going to go to the state competition in a few weeks. And we just want to say congratulations to our amazing teams. You've done a phenomenal job, and it's really difficult to have to select somebody, but that's just how these competitions work. We'd like to also share that the awards, the trophies, are going to be sent to the schools and will be available to the coaches for their year. Your name will be engraved onto the trophy for that year. And so I'd like to announce, without further ado, that the winner of the 2020-21 mock trial competition, and I want to make sure I get this right, is Team Q. Congratulations, Team Q, for winning. Team R, you are the runner-up. Congratulations. You're going to be, Team Q is going to be representing us at the state competition March 18th through March 21st. We are so proud of all of your great work, and congratulations. You should feel very proud of yourselves. Your strength and your resilience inspires us all. This has been such a challenging year. This has been a tough competition, and we are so glad that we were able to be a part of this with you, to support you through this competition. And we know that your future is so bright. Thank you so much for being a part of the 2021 mock trial competition. And we can't wait to see you next year. Congratulations, everybody. I would like to take a moment to thank Denise Pittman-Rosas for her great work in organizing the competition this year. She did an outstanding job. Thank you, Denise, for all your hard work. Michael Painter, Judge Volkman, all the folks that worked so hard, Celeste Gutierrez, and the amazing students who, coaches, scoring attorneys, judges, all the folks that came together to make this so wonderful. And thank you, of course, to all the parents for supporting your students. Thanks, everybody, and have a wonderful evening.